Hello.
The record will reflect that Mr. Brooks is present in the courtroom in person
Oh, yes,
and in custody wearing a suit and tie. Actually, his suit coat is off, but he's
yes.
still wearing a mask.
I did take it off.
And the jury will be brought out and you'll be asked to call your next witness.
Being called that name.
So noted.
And we still need to address subject matter jurisdiction
Yep. You got to address.
before the jury's brought out.
I will not be doing that.
Will it be proven for the record?
The record stands.
Why won't y'all prove it?
So is that a tacit agreement that you don't have to answer that question, Your Honor?
Hello.
I make no such
Welcome.
agreements with you, sir.
Welcome inside of the
So that
courthouse.
means you can answer
Court is
questions.
in session. Stay seated while I
Will we be
object.
addressing subject matter jurisdiction on the record, and will it be verified and proven? Non-responsive answer is a tacit agreement, Your Honor.
Jury's coming out.
I do not consent to being called that name, but I am here all the same. We are watching a replay of my current performance, currently in progress. I object to you all being here. But while you all are here, like, comment, and subscribe. Let's continue to watch. I'm not standing, even though I'm standing.
Thank you, everyone. Please be seated. The defense may call its next witness.
Who's here?
How you gonna ask who's here? Let me check.
Bertram, Hayes, Aldrich, and Lescano are
Let me check.
present and ready, Your Honor.
Thank you.
Let's see.
What was the last two?
Aldrich and Lescano.
Yes.
Let's go with Deanna Aldrich.
Deanna Aldrich.
I don't consent to
All right,
being
very
called
well.
that name. I'm going to hold myself in contempt, but watch this live, but object to any objections given by the plaintiff for objecting the statements given today. I object to you even saying that. If you could take a moment and watch. Damn, I gotta take my mask off. Why we can't decide? Look, you're gonna have to decide if we're gonna keep this mask on or not. I'm gonna take mine off, but I look different now. My beard grew back. You better decide. I'm not playing with you. And say another objection again, see what's gonna happen. Court's back in session. You said keep it on? Well, let me keep it on there. And keep my mask on there. Getting tired of this. Well, thank you, Shanice, for saying that. After all, this will be the last time I'm gonna look handsome. After all, it is alleged that I've hit or struck or permanently deleted 6 people. And since I have permanently deleted 6 people, I figured my conviction is probably gonna it's probably gonna happen anyway. So since it's gonna happen anyway, I might as
Sorry, I think
well,
she was in the other building, so.
since it's gonna happen
It's all right. Thank you
anyway,
for letting us know.
I might as well have fun with my own case. If you have not taken it into consideration, I object. You said this guy is clearly a psychopath. He would have done better to claim to be insane. I object. I object to you even saying that. Do you have subject matter jurisdiction to make that comment? Hello, April. Thank you very much for the opportunity for Instructor Mike to come out and read to your wonderful students at Blake Elementary. It's not Blake, it's Drake. Sorry, Drake Elementary School, where reading is fundamental. Do you have subject matter jurisdiction to invite me so that I can come and read to the children how to represent yourself? A new book coming out soon by Penguin Random House. I object. Well, thank you very much. As you can see, I am in deep study right now. Deep study. Give me 1 minute. For those of you all who are joining this live, please note that this is the trial of the state of Wisconsin versus Darrell Brooks, the man who is accused of permanently deleting 6 people during a holiday parade in November of 2021. We're going right back to the courtroom already
Good
in
afternoon,
progress.
Miss Aldrich. If you would please make your way to the witness
We are
stand.
answering ready.
It is up by me. It's up a riser. When you get all the way to the witness stand, please remain standing. Raise your right hand, and my clerk, Teresa, who's on my left and will be across from you, will swear you in. Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. Come up and have a seat. The first thing I will ask you to do is to state your first and last names for the record and then spell each.
Okay. Deanna Aldrich, Deanna. Last name is Aldrich.
Thank you. Go ahead, sir, your witness.
Morgan, what are you talking
Good
about?
afternoon, Miss Aldrich.
No. You talking about what I'm going through right now? No, it won't affect that. No.
Director,
I'm not in trial. This is a.
let me back up a little bit.
Oh my
What
God.
do you currently do for a living?
I'm retired.
That's always pretty good. Direct your attention to the evening of November 21 of 2021. Do you recall that evening pretty good?
Yes.
Where were you staying at the time?
I'll comment on that, Stephen, in a minute.
I live on Maple Avenue.
And during that evening, did you hear anything unusual?
I did.
And do you recall what that was?
I heard a large thumping noise in my neighbor's yard, and when I came out to my porch, I saw a red SUV.
Back up a little bit to the thumping noise. Can you describe that thumping noise? Would it just be a thumping? Did it sound like a crash or anything of that nature?
I believe it was like the engine dropping kind of noise.
Okay. And you stated you looked out your patio and saw a red SUV.
I did.
Do you recall how that SUV looked at that time?
It was smashed to smithereens.
Do you recall if the red SUV was still running at the time that you observed it?
Yes.
And at some point, did it cut off?
Yes.
And what did you see from that point?
Before I seen it shut off, I seen it go forward in the driveway and then back up like 3 feet And then someone got out of the car and ran around the bushes to the front of my building.
And who's the someone that you are referring to?
At that time, I didn't have my glasses on, so I could not see clearly.
What do you recall?
As far as
Description
what?
wise, yeah.
Dark hair, possibly white or purple or whatever color shirt, and dark pants.
Do you recall a height?
I think he was probably anywhere between 5'6" and 6 foot. I really couldn't tell because of the angle.
So I'm assuming then your patio is kind of on a upward base type of angle that you would have kind of been looking
I was
sort of
looking
down.
down, yes.
Okay. And the individual you stated ran in what direction at the time that you were observing?
My porch is here, and he ran from the driveway here around to the front of my building.
Did you see where the individual went from that point, or could you not see because of where you were positioned on the patio?
He stopped to, if you were looking at the building, he stopped to the right of the building front.
And the building front, is that a street?
Yes. Not all the way to the street, though.
Okay.
He was in the front yard on the grass.
Did you at any time observe this individual jump over the hood?
I was running in and out of my house, so I did not see because I was trying to find my glasses as I was running in and out.
So is it fair to say you were trying to locate your glasses so you can get a better look at what you were observing?
Yes.
Do you recall if the SUV had any tinted windows?
I wonder what the prosecution is looking at on their laptops.
Do you recall what time of the evening you heard the loud thumping and then observed the SUV?
I do not recall.
And before that evening, had you ever noticed that SUV before that evening?
No.
Did you
I'll
speak
answer
with
that,
any
Steve.
of your neighbors to inquire who the SUV may have belonged to?
No, there was people coming outside from the building that the driveway was, and they were gonna walk up to the vehicle, but they did not because I yelled to them and said, "Don't touch it."
So that kind of would be fair to say that kind of startled them and stopped them in their tracks.
Yeah,
Do you recall how many people there were?
maybe 10.
And at some point, did law enforcement come to your home and interview you about what you observed that evening?
Yes.
And do you know if they? Well, I'm assuming they took a report. Would that be fair to say?
They came up to my apartment and asked me some questions.
Do you recall if they were writing it down or recording it?
Writing it down.
You see her shake her head. She's like, this muta fuca. She was like, I can't believe I'm fucking here. She's like, it was
If you
deep
recall, did you-
namaste breaths.
Did you
All
ever
right.
learn what the loud noises were that you heard before seeing the SUV?
No.
That's how his hair is, I would
And
imagine.
the street that you observed the individual running toward, do you recall what street that would have been based on the direction?
Arlington Avenue would be right directly in front of that building.
You didn't see the individual run towards Maple Street?
He ran towards Maple Street and came around the bushes directly to the right of my patio, being up high.
When they go on
The
break,
general
I'll
direction
answer that
would have
question,
been-
Tracy.
What street did you say?
Arlington.
Arlington. I apologize. Were you aware that there was a parade going on that evening?
Yes.
Did you attend?
No.
They said a lot of his notes came from his previous court-appointed attorney.
After you spoke with the law enforcement officers that evening, did any more law enforcement officers come back and interview you at any time after that evening?
They did not interview me that evening. They came early the next day on the 22nd.
Oh, I'm sorry. After the 22nd, did any other law enforcement come back out to interview?
No.
Do you recall the name of the officer that interviewed you?
No.
No further questions at this time.
Thank you. Any cross?
No cross, Your Honor. Thank you.
Thank you, ma'am. You may step down. You are excused.
Yeah, the judge is being awesome. She is. Oh, you want to talk about an exercise of patience? That is definitely this judge. exercising a lot of patience. As you can see, we are looking through our files.
Just 1 second, Your Honor.
You all do understand the reason why they're letting him have this extra free reign. Because it's like,
Defense calls Christopher Bertram.
All right, thank you.
I think that the court and the state's attorneys are exercising an exorbitant amount of patience, a large amount of patience, because of the appeal. Yeah, I represented myself one time and won too, but it was on a misdemeanor case.
State heard that
It was not a felony.
Your Honor, my assistant.
I didn't
Right.
want to assume. So thank you for.
Oh, you're gonna object to leading to evidence. Yeah, they're trying to prevent a new trial. Absolutely. Because it could be overturned on appeal, and now you got to go back through this. And I think that the court is thinking about the 6 victims that were permanently deleted.
Please make your way to
Some
the
words you
witness
can't say.
stand, which is
And then the other
to my right,
victims.
it is
And
up
so when you're
one
trying to put
riser.
them
When you get there,
first, which
please
you need
remain
to,
standing, raise your
because you
right
represent
hand,
them.
and my clerk
makes
Teresa, who's on
sense.
my left and across from you, will swear you in.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Thank you. Have a seat, please. First thing I will ask you to do is to state your first and last names for the record.
My
It's
first name is
on,
Christopher,
buddy.
And my last name is Bertram.
Could you
It's
spell
on.
those, please?
CHRISTOPHER BERTRAM.
Thank you. As long as
I'm
you
sorry,
are
Your Honor.
close to the table, you will not have to lean in. Go ahead, sir, your witness.
Oh, I'm sorry.
Go ahead, your witness.
Oh, I forgot you was my witness. Okay.
First of all, good afternoon. What do you currently do for a living?
I do electrical work.
Directing your attention to the evening of November 21st, 2021. Do you recall that evening pretty well?
Not very.
Do you recall what you were doing that evening?
Yes.
And what were you doing that evening?
We were eating
Taking my
Pop-Tarts
car to our mechanic friend.
and practicing.
Were you aware of a parade going on that evening?
No.
Around what time were you taking your mom's car to be inspected?
I don't recall.
Do you recall seeing anything that caught your attention that evening?
Yes.
Can you state what that was?
A smashed up red car.
And do you recall where you saw that at?
I believe it is Prospect Court Street.
Street or court? Objection to my own witness.
And at the time you observed this smashed up car, as you say, did you see anyone driving it?
Yes.
And were you able to make a description? Sorry.
We can make a
Description of who
subscription.
was driving it?
We
I
can
believe
subscribe
so.
to this.
And what do you recall?
I don't recall what I said.
You don't recall what you said or saw?
I don't recall what I exactly said when I gave my statement.
Do you recall what you saw?
No.
No, I don't follow him.
You
Should
made
I?
reference to giving a statement. I'm assuming that would be to law enforcement. Is that fair to say?
Yes.
And did they write down?
See you, Chris.
Well, let me back up. How was that interview conducted? Was that an in-person interview over the phone, or?
In person.
And do you recall if the law enforcement officer was writing down what you were telling them or recording?
I'm gonna drop the link for the jury. That's what will be. Will be the jury.
Did you observe the vehicle stop at any point in time?
No.
So it was pretty much you just saw it just kind of just rolling past.
Yes.
Did you notice if the vehicle had any tents?
Any what?
Tents, like tinted windows?
No.
Do you recall in your interview with law enforcement? Well, let me back up a little bit. Was your interview with law enforcement the same evening that you saw this vehicle, or sometime after?
The same evening.
Do you recall stating during the interview that evening that you observed the driver as a black male with short hair and a short beard?
I don't recall exactly what I said.
Do you recall stating at any time during that interview that evening that you believe you saw the operator of the vehicle reach down and grab something as they were driving past?
Yes.
Did you ever see them? Did you ever see what you believe was being grabbed?
Yeah, I'm gonna wrap this up shortly too. I'm gonna watch it, but I'm gonna wrap it up.
And what did you think at that moment that you saw the operator of this vehicle reach down?
I was unsure.
Do you recall in your interview with law enforcement that evening stating that you thought it was possibly a gun?
Yes.
And where did you observe the vehicle go after it had passed you?
I turned away after it passed me.
Do you recall what the operator of the vehicle was wearing at the time that it passed you?
I do not remember.
Do you recall during your interview with law enforcement that evening stating that you thought the operator was wearing a black sweater or jacket as he drove past you?
If that is what is written.
If you all can take the chance to hit the like button, if we can get the likes up, I would appreciate that. Please, if you value content like this, I try. I know it's boring. His questioning is so boring. Oh, jeez. There were some
do you
exciting
recall
moments.
where your interview with law enforcement that evening took place?
Yes.
And where did it take place?
My house.
And was anyone present with you during your interview with law enforcement that evening?
Yes.
And who was that?
My mother.
And do you recall what agency your interview was conducted by?
Yes.
And would you stay for the jury and the record?
The FBI.
Do you recall stating in your interview that evening with law enforcement that you heard a lot of gunshots?
Yes.
And do
A
you
lot.
recall? I think that's a little bit unfair to say. If you had to estimate where where do you think those gunshots were coming from, like vicinity wise?
It sounded from downtown.
And when you say a lot of shots, what would you describe as a lot of shots?
Like a full magazine.
Ebony magazine, Jet magazine, or Guns and Ammo magazine? What do you mean when you say magazine? Hey, Ashley. Yes. Are you guys enjoying the show that I am putting on for you?
Do you recall seeing the vehicle that you observed crash into anything?
No.
Thank you, King James. For the record, I object to your
Do
comment.
you recall stating in your
I'm,
interview with law enforcement
I'm
that
talking right
evening
now.
that the vehicle appeared to slow down while traveling down Prospect Court?
Yes.
At some time after observing this vehicle, did you call 911?
Yes.
Do you recall around what time you called
I'm on
911?
YouTube
No.
as well, Jessica.
Do you recall shortly after seeing this vehicle uh, texting anyone?
Yes.
Do you recall who that was?
My girlfriend.
And what did you tell her?
I don't remember.
Do you recall telling her there's a shooting?
Possibly.
You said that lawyer is fine. Which lawyer are we talking about? What's up, Patah? No, that white guy is not gonna say. He not gonna say magazine. This is boring though. It's exciting. It's got its exciting moments. He
Did you see
just
anyone else in the vehicle?
oh dragging this shit along.
But you do recall seeing the operator wearing a
I
black
can't
sweater.
put you all through this. I value
Don't
your
remember.
time. That is correct. Double snake 007. That's correct.
Did you observe at any time that evening seeing someone
What's
running
up,
from the vehicle?
JFB?
No.
I will let him know you said that. You know she called you fine, right?
Do you recall why you would have gave a description that evening when initially interviewed by law enforcement?
Because I saw the person in the car.
And how did that person look?
Like
I
you,
don't remember.
like you.
Grounds.
This answer may stand.
What was the answer?
He said, I don't recall, or I don't remember.
No further questions at this time.
Thank you. Any cross? No. Thank you, sir. You may step down and you are excused.
What's up, LHJ19? Oh, I almost.
All right, go ahead and call your next witness.
And when we get to the next break, I have something to discuss outside of the presence of the jury. That pleases the court.
Do you want to do that now or after your next witness?
We can.
All right, I'll address a legal issue and we'll bring the jury back in when we're ready. I'll rise for the jury, please.
This is where shit's about to get exciting. I'm glad we didn't give up. It's going down. I want to see what the hell he about to address. Your Honor, could we address subject matter jurisdiction? Is it a judicial determination? Did you say you have to go walk your goldfish? Oh, God. Most patient judge ever.
Seat, and then we'll just wait for the door to close. Go ahead, Mr. Brooks.
You better not fuck it up.
I'm curious. Some of these, judging by the reports, how are some of these answers allowed to pass when they're coming straight from reports made by the people on the stand? Very curious.
I don't understand your question.
I don't either.
I'm not sure what you're asking me.
What I'm asking is, reading from the report that the people on the stand are giving, the report that they gave to law enforcement.
If you're asking me whether there's a mechanism in the rules of evidence and how to establish that before the jury, the
Thank you,
answer to that is
Stephen.
yes. If you're asking me how you do that, I'm not going to answer that.
Right?
Like, you're asking the questions.
I just
This is your witness.
to be blunt, which I've been since the beginning of this trial, obviously. I see the whole strategy here by the prosecution. I see right through it. Don't have any cross-examination, mainly because you've already schooled the people getting on the stand on how to answer certain things.
Well, that is completely speculative on your part without
It's
any
obvious.
basis in law or
It's
fact.
obvious.
Sir,
You talking about
you
trial
can ask
prep?
questions that establish that. You can ask them if they've met with anyone. You haven't done that. So for you to say that right now is without basis. If you want to,
It's clear.
if you are looking to elicit what they said in the report, there is a way under the rules of evidence based upon the way the witnesses have answered to clarify that. But that requires you to call certain witnesses. I'm not going to give you any more legal advice further than that.
I don't think I have to
So
call any other witnesses. That's
if
not
you're
on the
asking me to
stand.
strike their testimony based
I
on
didn't-
your
I didn't say
perceived,
anything
then that's
about that.
all right. Then I'm going to bring the jury back out and you're going to call your next witness. So I'm
So
not
is you-
hearing a request from you at this time. You said you wanted to raise a legal issue. What's the legal issue?
The legal issue is how is the state allowed to coach the
You're
people getting on the
assuming they
stand?
spoke to them and coached them.
It's obvious. I'm not stupid.
Well, I disagree with that, sir. Again, you
Wait,
can
wait,
ask
wait, wait.
All of a
questions to
sudden-
lay a
All of a
foundation.
sudden, the state
with these
don't got.
witnesses.
Wait.
All of a sudden, for the first time in
I'm
trial,
not stupid.
all of a
I
sudden now
disagree
they
with
don't
that.
got no cross. That's clearly
You
a
didn't
rush
twist
to
that.
try to get through the case. Hurry up. We just gonna let these people go.
Well, this
and
is
not-
argument.
Come on, man.
This is argument on your
I
part,
see
sir. It
through
is
it.
pure
I just
commentary
want
at this
that on the
point.
record. I see through it.
And your
Nice try,
see-through
but I see through it.
has absolutely no basis in
Look,
fact.
I
I
know
told you to
that's what's
stop
being
fucking
done.
it up.
You could
Come on, man.
ask these questions. You could
Come on,
ask
man.
these
We got the right
witnesses
one.
certain questions,
I'm
and you're
far,
not.
far from an idiot.
They're your witnesses, sir. If you believe,
So I'm gonna start asking every witness up here that they seem just to mysteriously now not have any cross for. Have they been coached to answer the way they answer? Because
well, you can't
I
ask
find-
that, but
I
you can
find
ask
it
them
very
if they've
funny.
met with anyone ahead of
I
their
find it
testimony
very
here
funny.
today,
I find
which
it
you've
very
done
funny.
with other witnesses.
I find it very funny that these are their reports, and now all of a sudden you can. Oh, I saw the person in the car. Oh, but
Mr. Brooks,
I
this
saw
is
them
an
reach for
attempt by
something.
you
Oh,
to
I don't.
delay these
I don't recall
proceedings.
what they had on.
Mr. Brooks,
You can
there's no
recall seeing
purpose
somebody
for you
reach for
saying
something
this
and
right
don't
now.
know what they had on. I find that
All right,
very.
I'm having the jury brought out. I'm
She not beating her husband.
to
Come on, man.
avoid the commentary when the jury comes out, or you will
I didn't
forfeit
say-
your right to be
I didn't say
present.
nothing. You.
Yes, Dale.
We need to pick up potential as to a witness by the name of Abel Lescano. He has prior criminal history.
Thank you.
So as long as the jury's out, we should probably discuss that. I would like to provide the defendant and the court with a copy.
So that had to
of
be
the-
said. So it's the defendant.
That's not how it was said.
That was
Oh.
how you said. You want to run the record back?
Mr. Brooks,
So I'm the only one. I got one. I
Mr.
got one
Brooks.
ear that work, and I heard that.
this
Come on,
is to
Come on,
benefit
man.
you so
No,
that
it's
you
not.
understand
Ain't none of
your
this to benefit me.
witness
So let's
has
be
a
clear about
prior
that.
record.
Your Honor, when I leave the table, I'm away from the courtroom and I have to elevate my voice. This is the
So she had to
alleged
elevate her
record
voice
of Abel
just for
Lescano.
that.
Stop talking.
Come on, man. Like I don't know who y'all be thinking y'all fooling. I accept the value in return for value. This document.
One more interruption and you're going to be removed to the next
That's
courtroom.
what you want to do anyway.
You can't
Not what
handle
I
the
wanna
truth.
Do not interrupt Attorney Opera.
So can
Your
you
Honor,
tell,
I
can you
believe he
explain-
has 7 prior criminal convictions via OWI second from 1997, and OWI third from 1997, and OWI fourth from 2003, criminal trespass dwelling from 2006.
All right, I need to take a break. This man right now is having a stare down with me. It's very disrespectful. He pounded his fist. Frankly, it makes me scared. And we're taking a break.
What is that? Oh my God. Did y'all? Oh my God. Oh, I can't. I. What? What? Oh my God. Operating. It could be operating without insurance. It could be driving under the influence. It could be a variety of different things. Oh my God. Oh shit. We got to go back and look at that. We got oh my God. I got to go back and look at that shit. Hold on. Hold on. Wait a minute.
This is the
So she had to
alleged
elevate her
record
voice
of Abel
just for that.
Lescano.
Stop talking.
Come on, man. Like I don't know who y'all be thinking y'all fooling. I accept the value in return for value. This document.
One more interruption and you're going to be removed to the next courtroom.
That's what you want to do anyway.
It's not what I want to do. Do not interrupt Attorney Opera.
So can
Your
you
Honor,
tell,
I
can you
believe he
explain-
has 7 prior criminal convictions via OWI second from 1997, and OWI third from 1997, and OWI fourth from 2003, criminal trespass to dwelling from 2006.
Right, I need to take a break. This man right now is having a stare down with me. It's very disrespectful. He pounded his fist. Frankly, it makes me scared. And we're taking a break.
Oh my God.
Disrespectful. He pounded his fist.
Do y'all see this face? Oh, what is this supposed? I'm sorry. Hold up. Oh shit. What is that, y'all? What's up, Holloway? Oh God, what? Okay, so we are on break from the trial. This is the last thing that occurred after he. Oh shit. Yes, that's what this is. He's mad because he's losing. He chose to, excuse me. I accept for value and return for value all this document. And that's what this is. He's throwing a tantrum. He's throwing a tantrum because, first of all, it is said that anyone who represents themselves is considered a fool for a client. Now, let's take into consider. Yes, this is definitely meme worthy. Let's take into consideration the fact that I find it hard to believe that a jury would acquit him of these charges. Stranger things have happened. People versus O.J. Simpson, right? We don't want to keep citing that case because that could be an anomaly. But when you are alleged to have taken your red Ford Escape SUV, and you are alleged to have hit and permanently deleted these people illegally, intentional homicide. One, I see why he represented himself. I mean, if you're going to be convicted of permanently deleting 6 people, what do you kind of have to lose, right? Now, I will say, I've been watching this case. I've been watching this trial. There have been some good moments. There have been a lot of questionable moments, a lot of bad moments. And there's been some good questions that he has asked. It's just a horrible case. And this is a horrible case of you representing yourself. This is a horrible case. An easy case for the state because he's been bringing in evidence that's been helping the state. Really has. Yeah, this is a horrible case. Let me see if they're back on the record, which they should be. Let's see if we're back on the record. Nope, not back on the record. Still watching the clock. Actually, we're not watching the clock. We're not back on the record. Yeah, this case has been horrible. So what are your thoughts about the case thus far? We'll keep it right here and keep a watch. And by the way, under the rules of not the rules of evidence, but pursuant to Title 17 United States Code Section 107, we are using this video for teaching criticism, comment, things like that. And this is exempt from copyright law, or copyright claims. You said Math Boy. Math Boy is about as bright as a 15-watt bulb. He's delusional and whacked for sure. Absolutely, Patan. I know what Patan wants to do. Jessica says, I do think he's bipolar, but that has no bearing on this case. The judge asked him previously for an offer of proof that the letter that he received in custody came from his ex-girlfriend. And the judge was trying very hard to kind of give him some pointers. Are we talking handwriting? Are we talking about linguistics? She didn't say that word. But yeah, you're right, Dale. Linguistics, is it a pattern and manner of speech? Something that you actually recognize. Something that you actually recognize is something that will lead you to believe that this letter that was sent to her or sent to you is by her. Try to, tell him that. He wasn't able to say anything. He wasn't able to give an offer of proof of the matter asserted. And this is just a horrible case. And so if ever is the case of not representing yourself in a situation where it is alleged that you have taken the life of someone, this is that case. Now, like Damien said, and like I said before, I represented myself in a criminal case. It wasn't a felony, no, and it damn sure wasn't a murder, right? It wasn't that. But if, and there have been people who have represented themselves and have had some bit of success, but it's not ever recommended. You know, if you've been watching this trial, you've been hearing him make the assertions that he has, no problem, Wendy, that he has not been given a fair advantage. But that's what happens when you represent yourself. That is what happens when you represent yourself. Hold on, I'm going to come back. I'll be right back. Be right back. I got something for y'all. We're going to come right back. I got to change it up so it could be more official. Because right now, I'm acting as Darrell Brooks. Y'all going to laugh at this. It ain't going to take long. Course in recess. All right, we're back on the record. All right, so here we go. I've been trying to sit here and tell you all that, you know, we're back on the record in the matter of the people of the state of Wisconsin versus Darrell J. Brooks, otherwise known as Lil Tupac. Look, you said you think he's bipolar. Let me go through the comments. And I'm not, for the record, I am not a judge. I just play one on TV. Chicago PD, by the way. All right, here we go. So you said, I know his mother must have had a hard time raising him and gave up after 4 times. Is that how he got his rapper name? I don't know. That's one thing that's not being capitalized in this case. I don't know if it would have any bearing as to his childhood. I do know that his mother stated that she wasn't going to testify on his behalf or even come to court. I think she said that she wasn't going to even come to court. I would really like to know, not that it would provide any excuse for this, but I honestly would like to know if he does have any childhood trauma. And I think that it is unpopular, if you will, to try to take this situation and then connect that to any childhood trauma he might have had, but it's not an abstract concept. You know, you look at the situation of, we're going to go ahead and take a dive for a minute. You look at the situation of Robert Crimo, right? When looking at the situation of Robert Crimo, you look at the things that he's been through, the traumas that he's been through. And it is the case that when you look at rational choice theory, the study of criminology, yes, and when you look at the study of rational choice theory, Shanice, look what she did. Look at this. I had to take a, hold on. We got to take the jury out of the courtroom. Take the, all rise for the jury. Wait till the jury clears the courtroom. Hold on for a minute. Wait till the door closes. Doors closing. Do y'all see what Shanice did? Look at this. Look, this don't make no sense. And this is why we have a problem in the court. Y'all see the face that she put right there? Mr. Brooks. Okay, bring the jury back in. All right, so. Yeah, I get what you're saying, Patah. There is no excuse for what he did. I get that. And you are absolutely correct. But I think when we begin to look at motivations, right? Biological, social, emotional, cognitive force that activates the behavior. There are motivations that motivate and push a person to do and perform actions that are inexcusable. And I think that's where we as a society, it is incumbent upon us as a society, if we're trying to find a remedy to these issues, you know, that they say, what is it? A ounce of prevention is more than a pound of cure. Does that make sense? Now, after having seen a bald head that's coming into the shot, we might be, it might be the case that we might be going back on the record. So now I'm going to help my colleague, the judge, you know, as much as I can from the bench over here. And for the record, I am not a judge. I am not even an attorney. I just play one on TV. And I know a little something about the law. The cases are real. The issues are real. Judge Mike. No? Okay, I tried it. You said, I think that his motivations were his life sucked and that he was mad he saw people having a good time. That could be possible. That could be possible. You're not wrong. You're not wrong at all. But I like diving into childhood. And don't think that I'm having sympathy for Mr. Brooks, but empathetic for the purposes of helping to prevent things like this. You see what I'm saying? And I think that's a road that's not traveled that often. You know, I would like to know how many times has he done things like this? How many times has he done things like this? How many times has he engaged in certain kinds or patterns of behavior? And what, if anything, did his mom do in his childhood, adolescence, adult? You know, and I get it. Some of you are going to say, well, it's not for his mom to do everything. He's a grown man. How many people are anatomically grown but intellectually a child? You see what I'm saying? What's the purpose behind Maslow's hierarchy of needs or other equivalent theories? You said the agreement between him and his chick, or the disagreement between him and his chick, may have pushed him. It's very possible. And it's not excusable. That's not what I'm saying. Not what I'm saying. Not what I'm saying. It is not excusable, but ounce of prevention, pound of cure. Because no matter what happens, Mr. Brooks is likely going to be convicted of this crime by a jury of his peers. It is unlikely that they are going to acquit him of this trial, of these charges. He, in my opinion, non-legal, not a judge, just play one on TV. He, in my opinion, has not provided any exculpatory evidence that would exonerate him. He has not provided any evidence to state there was a reason, legal reason, that we as a society could say, okay, this makes sense. He has not provided any mitigating circumstances, any mitigation, things that would go in his favor. Right? And so I do think that the argument, the disagreement between him and his girlfriend, ex-girlfriend, you know, did play heavy on his decision to do this. Again, for the record, not excusable, but I get it. And so this is why it is important. Hold on for a minute. This is why it is important to allow children to have a voice. You think about it, and the clock is still ticking. So this is not paused, by the way. So when they come back on the record, as you can see, this hand is moving. So when they come back on the record, I will silence myself from the bench here so that we can hear the Honorable Judge Darrell, right? Beauty Gets Fit US. You said, yes, Mike, rarely do we dig into mental health for prevention purposes. Clearly, this man is mentally challenged and not well prepared for life. Stress, hell, even reality. He is anatomically an adult. Yes. And the thing is that I look at it that This is why I love the position that I take as an abused child advocate. This is the reason why I write triggering posts. This is the reason why I say things that I say to get people to be triggered and incensed enough to recognize how their abused child may feel. And you may think, well, my child is doing good, got good grades, got good this, got good that. Okay, that's one half of their life. But then there's the other half where they feel ignored. They feel as though no one listens to them. You know, they act out they act out behavioral issues, right? And it's easy to sit there and get them put on ADHD medicine. It's easy to sit there and get them put, or get them some kind of evaluation. I deal with a lot of people who come to me and say, Mike, I need you to help me because when I was a kid, I was acting out, I was this, I was that. My mom took me to Hartgrove, right? My mom took me to Hartgrove and got me a mental health evaluation. And now as an adult, it is affecting me. I wasn't crazy. I just wanted her attention. I wanted her to talk to me. I wanted this. I wanted that. And it's always her. I have not seen them come forward and say, my father did this, though it does happen, right? But if you don't know what kind of parent you are, how do you know you're providing everything for your children? It is not a crime to seek help. It is not a crime to say, I don't know what I'm doing. It's not a crime to admit to your children you don't know what they're doing. It's not even a crime to be angry. You have the right to be angry when they do things that you don't like. 3 things that people do when it comes to anger. They stuff it, they escalate it, and they manage it. When you deny your feelings and then you allow your child, or you deny your child their feelings, we stuff it. It's still there. We just can't express it. So we stuff it. And then that stuffing turns into an escalation of the constant pressure of constantly being denied your feelings. Doesn't mean your feelings are right or wrong. They are just that and need to be expressed. It's like pressure, right? And then if you're not aware of the trauma or the things that motivate you, fuel you, affect you, then you escalate it. This was an escalation. Him taking that car. And if you saw the video in trial or at trial, right? If you saw how fast he was driving, he wasn't driving. Like, there was a vehicular crash that involved. Oh, whoa, I'm going to read that comment in a minute. You are so correct. When we look at, there was a situation that happened on the 7100 block or 7000, about 7059 block of Jeffrey, where this man came out of a LGBTQ bar, right? That's how it was advertised or how it was stated in the news media. And then there was a conversation that led to this man going to get his car and driving at a high rate of speed at some people who were in the middle of the street. That was extremely fast. This situation, he didn't drive fast, but he still did drive his car through that parade. And then he accelerated his speed. And he ended up permanently deleting the lives of 6 people and injuring hundreds, right? And so we're not trying to make a comparison per se, because both of them are equally as wrong. They're equally as wrong. But when you look at the escalation, when you look at his trauma, it doesn't provide an excuse, but it definitely provides a line of reasoning to get you, me, us, to pay attention to our loved ones, to our children. Because don't admit this on the record. Don't do that in the comments. But how many people do you know, maybe yourself included, where you are just a few away from a full parade, for the lack of other terms? You see? And so it's very important for you all to find people or find a person to reach out and speak to. I disagree, Dreaming. I disagree, Dreaming Frost. You said the judge is absolutely terrible for allowing this behavior to continue. And with your statement right there, 9 times out of 10, if they would have gotten this trial to conviction, he would have gotten an appeal regardless. It's going to happen. But it could be grounds for appeal. And though I kind of had the opinion slightly, I understand why she's doing this. See, she can never be punished per se for the delay because it's reasonable given the circumstances. And when you look at this case as compared to other cases, right, where there might have been a rush to conviction and not giving him, because he's acting as pro se counsel, which he has every right to do. The state has assisted him when they don't have to. The judge has assisted him when she didn't have to. And the decorum, see, here's this. This is how I can tell that some people, I don't want to say some of you all, but some people don't even have the patience for when their children throw tantrums and you're quick to use violence to suppress them. You're quick to use that. Remember previously when I said there is the education of what you need to know, right? This is teaching now, the education of what you need to know. Then you have the failure, because failure is a part of success if you learn from it, right? And then from that failure, you have the recovery, teaching you how to recover yourself after we recover you, okay? Then you've got, we're almost back on the record here, okay? Then you see, you got his mask on, right? Then you've got, here we go, education, failure, recovery, achievement, humility, right? Assessment, how you learn, how people learn. Then you've got the assessment of whether or not you've learned and mastered this body of education, your knowledge, skill, ability assessments. Then you've got energy, patience, and time. Energy, patience, and time. The state is choosing to prosecute this man. What's the rush? If he's going to be convicted of 6 permanent deletions, he's going to have 6 life sentences. What's the rush? Do we want to risk the case being overturned on appeal because of a rush, because we are impatient? We put this man to trial. We are seeking to take his freedom from him. The case is already ours, kind of, sort of. What's the rush? Let him have fun. The judge is trying to prevent a mistrial. Why subject a future judge to this horrible display for the future and for the victims? The jury are the triers of fact. The judge is the judge or the trier of the law. She has to keep it together. But the people represent the victims. And so it is incumbent in the interest of justice that the judge do just that, not rush it.
They were before.
We're back on the record.
I'd like to continue by bringing the jury out momentarily, Madam Clerk, and having you call your next witness. I trust that you're ready to do that, sir.
Twins. I'm sorry, I'm just playing. Okay,
Right, then.
we're back on the
We
record.
need to keep
Okay.
the task of
Oh,
the
we do.
trials for Mr.
I knew I would left something in my office, but I reviewed it, so go ahead. What is the state's request then as it relates to the prior record?
We believe the proper answer would be 7 prior convictions, Your Honor, and that would not obviously be counting the OWI first conviction from 1993, which is at the top because it's the age of that, and obviously that would not have been a crime, but everything from OWI second on down, we believe would be appropriate. There's also one that's noted, 06 CM 2039. it was a case, but all the charges were dismissed and read in, so we're not counting that file either.
Can you go run and get that for me, please? Thank you. Just gonna have that brought back out. I took it with and I left it on my desk. And then remind me the statute again on priors.
90609.
Thank you. And a copy of the record was provided to the defendant.
It was. It has not been discussed with Mr. Lizcano.
That was going to be kind of my next topic once. Thank you. I look at this again. All right, Mr. Brooks, do you have a position on the prior convictions for this witness? The state is asking for a determination by this court that there are 7 prior convictions for purposes of questioning the witness, whether that's by you or by them if they so choose. And that would be for a determination under 90609.
He don't know what that shit is. How you see his eyes? That's a what the fuck? He don't know what that is. 90609, it might be. Objection.
I don't know what you're asking.
Mr. Brooks, you may recall at some point, I believe we had a discussion about prior convictions. I think maybe we only discussed that if you were to testify, we would have to have that conversation. So in fairness, I don't.
No, there was one state's witness that had one prior that we discussed. In
That's
the court
right.
ruled.
We did. I recall that. So at that point, I directed your attention to 90609. And then I made a ruling based upon the factors that are enumerated in that statute. You've been provided with a listing of the record. I would direct your attention to, I'm not sure if I see that book out there, but the statute book that I previously provided to you, but that the 90609 would be in there. But in any event, the state is asking that I make a determination about how many for purposes of the questioning of this witness. Do you have any comment, statement, or position on that?
You can make an argument depending upon the type of.
Looks like it's 9 on here.
Which is the one the state referenced that the charges are listed, but they were dismissed?
2000, well, it's recorded as 06 CM 2039, 2 times violate harassment/restraining order, and then it says DM/RI, which means dismissed and read in, 2X MBJ, which would be 2 times misdemeanor bail jumping, dismissed and read in. So no convictions from that file.
So why is it on the sheet?
Because it hasn't been expunged. This is why it's important to get your stuff expunged.
Listing of the cases that you found when investigating.
I'll tell you in a minute.
Background.
Yes, Your Honor.
And nothing since 2007.
That's correct.
All right. Any statement you want to make, sir, on what the number of convictions this court should consider under 90609?
What is dismissed and read in? Does that mean there was no charge?
No, it means it was when there was a conviction for something else, the charge was dismissed and read in, and then the court considered it at the time of sentencing. So they are not convictions, but it was a case. So that's why, my understanding why it was listed.
Still a part of your record,
So
and it's fair game. If it's there, they can use it.
So where it says dismissed and read in, that would be the restraining order and the MBJ.
Right, misdemeanor bail jumping. So 2 counts of violate harassment restraining order were dismissed and read in, along with 2 counts of misdemeanor bail jumping dismissed and read in. I'm guessing, but the state can confirm that it either was read into 06 CM 1859 or 06 CM 3149.
Yes, I believe it was the 1859 case, Your Honor.
So at the time of the conviction for resisting obstructing, there was a misdemeanor bail jumping dismissed and read in, and then the other charges, all of which are listed under 06 CM 2039, dismissed and read in.
So then 8 should be 8.
The OWI first would not be criminal, as I understand it, and so I believe that's why it's not, the state did not ask it that it be counted. Because the statute requires conviction of a crime or an adjudication of delinquency.
Operating
So
while
there's
impaired.
no
That's what that
crime
means.
For OWI.
An OWI first would not be a crime, it would be a forfeiture.
Yeah, I didn't know. I didn't even know what it was. Honestly, I'm looking it up now. So it's operating while impaired. Yeah, it's under 34663 of Wisconsin statutes. It's OWI. And the first offense is a monetary penalty of $150 to $300 of forfeiture, no period of confinement.
All the way up to a 5th.
Remind the parties of the factors to consider for exclusion include the lapse of time since the conviction, or in this case, convictions, the rehabilitation or pardon of the person convicted, the gravity of the crime, the involvement of dishonesty or false statement in the crime, the frequency of the convictions, and any other relevant factors. So based on that, do you have any argument that it should be less than that?
Less than what, 8?
Well, it'll be less than 7. He has 7 convictions as I count them.
And that's not counting OWI first.
Correct, because it's not a crime. It can't be counted under the statute.
Then it's 7. Should be 7.
But they said
All
7.
right. Do you want to make any argument
They said
about
7.
whether any should be excluded under the statute based upon the factors I just read to you?
Well, you already made reference to one of them not being a crime. So that brings it to 8. I don't understand the whole.
Well, for example, the last conviction was in 2007. It's now 2022. So do you want to make an argument to the court that perhaps he's been rehabilitated?
She's giving them the fucking argument. Make it. Sorry, I can't curse. I'm a judge on TV. Sorry. Excuse me.
I don't want to speculate on.
She gave you the argument. You.
But if it's 7 on here,
She gave you the. All right. So.
well, I guess it brings it to 7. And
Okay.
whether OWI first is not a crime,
He's still hinging on the wrong thing. That's not even a
it still
thing.
counts as what it essentially is nowhere to get to 2, 3, 4, and 5 without the first.
She gave you the.
It's like 7 to me.
All right, then. Anything further from the state on this? given the number of convictions, factually, although the first one's not a crime, the OWI first, Mr. Brooks is correct, is from 1993, and without that, you don't get the other criminal OWIs. But I would note the criminal record is from 1997 through 2007. That spans about a 10-year time span. It's now 2022, but there's essentially an agreement by the parties that there are 7 convictions that are listed here. I've looked at the lapse of time since the convictions. I don't know about rehabilitation or pardon, other than it looks like he did complete the earned release program.
I wish, but
which would have resulted in a reduction of initial confinement and then converted to extended supervision. I don't see.
if she would, damn, this would have been an easy motion. I would have argued this motion.
Of probation listed, meaning that he was revoked. I see some extensions, but that could be for a variety of reasons. But given that there was a pattern with the OWIs, that the last one was a felony, that goes to the gravity of the crime. And the other issues, I'll find that for purposes of his testimony, that this witness has 7 convictions. He may be asked, have you been convicted of a crime? His answer should be yes. And then the follow-up, how many times? The answer will be 7.
That will have to be told to Mr. Lozano before he testifies, Your Honor, I believe.
I agree. State willing to relay that information.
I'd rather not, given the accusations levied by Mr. Brooks. I think it's better we do it in open court, Your Honor.
All right. Who's your next witness? Will it be Mr. Lozano? Because if it is, I'll just have him come in now and I can put him on the stand and advise him of that.
May I ask who's present right now?
For sure, Mr. Hayes and Mr. Lozano, and I'm not sure the 330 witnesses, I think, are probably on their way. They're on their way.
Right,
So-
Hayes and Lozano are still here.
Yes.
All right. Those are the 2 who are here, sir.
So while they're calling people in under 90609,
I'll tell you what,
exclusion.
Either way, let's just bring Mr. Lozano in case he's not your first, but then I don't have to deal with the interruption with the jury. You don't have to call him first unless you want to, but I'll just bring him in and advise him. So if someone from victim witness could bring him in, please.
So here we go. Evidence of a conviction of a crime or an adjudication of delinquency may be excluded if its probative value is substantially outweighed by the prejudicial nature of mentioning these things.
ABEL.
There are several factors, and if he was able to look at the rap sheet, I don't know what they call it in Wisconsin, he would be able to.
Subject matter jurisdiction, Your Honor.
Oh no, not this subject matter jurisdiction stuff. But he could be able to articulate that
Be verified and proved.
this is what his test. This is what I'm going to ask him. This is the offer of proof for his testimony, and this is the proof of the matter asserted. I mean, that's just in my elementary knowledge of this statute. Yes, he was convicted of these things. He was convicted of these 7 individual situations. Yes, it had been a lapse. And what does it say? The statute says
paperwork from Mr. Hayes.
lapse of the time since the conviction, rehabilitation of the person convicted, gravity of the crime, involvement of dishonesty or false statement. If there were no false statements,
Yes. We
and his
will
testimony, if
accommodate that
anything, had always
request.
been
It'll just take
truthful,
me a minute,
there's
Your
nothing
Honor.
to assert
Find
or
it.
to state that he would not be
I'll have to
truthful
have it
in
printed
his
and brought
testimony
over.
here.
Or Mr.
And that his
Michelle can run. Thank you.
testimony is
I would
probative
change
to the
it
matter
to
because
Catrice
I
and
intend to bring him on the stand to
Well,
testify as to this.
It's part of
No.
a 700-page PDF, so I can't just email one page.
But it wasn't a crime of dishonesty. Absolutely.
I see.
At least I don't know how to do that. Copy and paste it into a Word document.
That's all right. You can do it the way that you need to. All right.
Yeah, I would. Yeah, it's too much.
Mr. Lozano, I'm just going to have you for a moment take a seat. You're not going to testify just yet, but just come up and take a seat just at the end of my jury box for now. I'm not going to come to the witness
Yeah,
stand.
it would be an Illinois
I
law
want you-
too.
Everyone can have a seat. I
He
want to
wasn't
advise
convicted
you
of
that
perjury
I'm
or
aware you have a
obstruction of
record.
justice or anything
So
like
for
that.
purposes
And we
of
don't know. We don't see
testimony,
that.
I've made a determination that if asked, have you been convicted of a crime? Your answer should be yes. And then if someone asks the follow-up, how many times? The answer to that is 7. Have you heard me say that?
Yes.
Do you understand that?
Yes.
All right, thank you. I'm not sure that you'll be called next, but I wanted to do that while I didn't have the jury here. You can go back out into the hallway then. Thank you. All right, then let's have the jury brought out, please.
Yeah. That's that fool for a client head rub. It's a lot. Boy, the pressure is on. The heat is on. You say he just wants a cigarette. How do you know that? How did you go research that? That is an awesome face. Yeah. I can't. That is I'm going to capture that too. How do you know you looked him up? You looked him up, didn't you? You did that name research. Oh my God. Objection to the face.
Thank you, everyone. Please
That
be
don't mean
seated.
you know that don't mean
Defense may
nothing.
call its next witness.
That could be his anti-woman stuff because he could be. Never mind. I can't say it from the bench.
Defense calls, is it Jason Hayes? Jason?
All right. We'll have the witness brought in. Is it Haynes or Hayes? Does anyone know?
No N for the best of my knowledge.
Hayes? All right. Good afternoon, sir. If you would please make your way to the witness stand, which is on my right. Upper riser. When you get there, please remain standing. Raise your right hand. My clerk, Teresa, who's across from you, will swear you in.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Thank you, sir. Please have a seat.
The case is.
First thing I will ask you to do is to state your first and last names for the record and spell each.
Jason, Jason, Hayes, Hayes.
Thank you. Go ahead, sir. Your witness.
Just 1 second.
I thought you did. I thought you was. His name is Thomas. Damn. His wife is Bridget or Barbara.
Accept for value and return for value this document.
Oh my God. That's what we feel too.
Good afternoon, Mr. Hayes. Is that how you pronounce Hayes?
Yep.
What do you do for a living?
I'm a retail sales associate for a food broker, Damon Worldwide.
And is that worldwide
for a
or
long time?
worldwide?
21 years.
Yes, all the time. The evening of November 21st, 2021. You recall that evening pretty well?
Fairly well, yes.
What were you doing that evening?
Went to the parade.
Did you go to the parade with family, friends?
I went there with my daughter.
Do you recall what time you arrived?
30 minutes before the parade started.
You say boats and hoes. What?
Were you scheduled to do any
Live on
marching in
YouTube.
the parade itself, or
No.
just spectating?
Instructor Mike.
Yes.
We're looking at the case. Darrell Brooks in Wisconsin.
Just for the record, did you say yes to being a spectator?
Yes.
Thank
That's
you.
what I thought he said.
Yeah.
I just wanted to make sure there was.
Yeah. He answered.
Excuse me. You gonna tell me he answered?
Anything unusual catch your eye that day that you recall?
Yes.
And what did you see?
Besides the parade,
Yeah, I'm sorry. That was unusual that caught your eye that evening.
well, where we were, yes, a red truck came through where we were.
Yeah.
It honked and swerved.
I guess I want to back up a little bit. Where were you positioned at that
We
time?
were all the way at the beginning of the parade.
Okay.
Like it was Main and the corner of Main and White Rock.
Okay. And you said you observed this vehicle honked and swerved.
Yes.
What did it swerve from?
I'm sorry.
What did it swerve from?
Where?
Or was it, I guess the correct question would be, why did it swerve?
I don't know. I wasn't driving. I don't know what his intentions were.
We're watching the trailer.
And
Darius Brooks.
you stated that the vehicle honked. Was that just a single honk, or was it a beep beep, or
One honk.
do you recall stating that it honked several times?
I don't
And
recall.
when you were initially.
I don't recall.
Go over to YouTube
So
if you don't mind.
well, before we get to that, did you see where the vehicle went
Instructor
after
Mike.
it honked and swerved?
Yes, it kept on going straight
see
down
that.
Main East. Well, the same route the parade went.
Did you get a description of who was driving the vehicle you saw that
I
night?
did not.
Did you get a license plate?
I did not.
Do you recall if the vehicle had any tinted windows?
No.
And I'm assuming at some point you either were interviewed by law enforcement or seek to be interviewed by law enforcement.
I did. By a detective.
And do you recall if that was the same evening, or
It was not the same evening.
so
It was a
that-
couple
days
days
prior?
after.
Do you recall in that interview that you had with the detective stating that your kids were playing in the roadway and the operator of the vehicle honked the horn several times and veered to the left around the kids?
Yes.
So in your opinion, it wasn't trying to strike the kids.
Correct. Yes.
And after it continued, I think you said east.
Yep.
Would that be correct? East?
Yep.
Did you see the vehicle strike anyone? When
I
you
did not. No.
Objection, you're sweating. I'm sorry. I'm supposed to be the judge.
Do you recall what side of the street the vehicle was traveling on at that
It
time?
was on the right side.
The right side.
So we were on the north side of the road.
So the right side would be.
Yep.
Did you see the vehicle stay on the north side of the road for the duration of the time that you observed it?
Yes.
So you never saw it go to the other side of the road, or?
No.
No further questions at this time.
Thank you. Any cross?
Yes, just briefly.
Mhm.
Good afternoon, Mr. Hayes.
Good afternoon.
Thank you for your attendance, sir. Mr. Hayes, do you remember seeing a police officer at this intersection as well?
I don't recall.
Okay. Do you remember writing in your report or telling the police officer that a police officer chased the vehicle on foot?
Objection, leading.
Overruled. It's cross. You may answer.
I do remember that I thought I saw a police chasing after the car on foot.
Okay. And do you remember also telling the same officer that the SUV took off down the street and that it accelerated?
Yes.
Objection.
Is that,
Hold on, there's been an objection.
I guess the objection to be what officer is being referred to wasn't clear.
Overruled. The state may continue asking the question.
I guess I was asking was that referring to
Um,
the interview officer?
Your
or-
objection is noted. It's overruled. The state may ask the question fully.
is that your recollection, sir, that the vehicle sped off and accelerated away?
Yes.
Objection speculative.
Overruled.
Do you also recall telling the officer who interviewed you that the driver of the vehicle had a dark complexion and a beard?
Yes.
Is that accurate with your recollection of the driver?
Yes.
But you didn't see a face, you couldn't
No.
identify anybody beyond those?
It's cross-examination overruled.
Hold on. There's been an objection to leading. It's overruled. The witness may answer.
No.
All right, thank you, sir. Those were all my questions.
Thank you. Any redirects, sir?
Briefly,
Not ever brief.
very briefly,
It's not ever brief.
you made a reference to the driver of the vehicle having a dark complexion. What
The
would you
fuck are you
consider a dark
asking? They said they
complexion?
could identify you.
Dark complexion. I don't know.
It is kind of hard. Did you notice any clothing?
I did not.
I'll call you
know.
back.
Did you notice any hair?
No.
No further questions.
All right, thank you. You may step down. And you are excused. The defense may call its next witness, please.
Quick question before I do: who's supposed to be arriving at 3:30? Just so I know.
I'm not sure.
Fabias and Darrell will be here at 3:30. Mr. Liscano is here now, Your Honor.
Thank you.
I knew who's here now. Just trying to get clarity.
Are you going to call Mr. Liscano?
It would appear so. He's the one that's here.
All right, then he may, the defense is calling Abel Liscano, correct?
The defense is calling Abel Liscano.
All right, very well. We'll have him brought in. Thank you. Good afternoon, sir. If you would please make your way to the witness stand. When you get there, please remain standing, raise your right hand. And my clerk Teresa, who will be across from you or is across from you, will swear you in. Thank you.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Thank you, sir. Please have a seat. First thing I will have you do is to state your first and last names for the record and spell each.
Abel Lascano, Abellazcano.
Thank you. Your witness, sir.
Good afternoon, Mr. Liscano.
Is that even his last name?
Living currently.
Just made that shit up.
Hairdresser.
No judgment whatsoever on this question. Have you ever been convicted of a crime?
Yes, I have.
And how many times?
7.
Do you recall the night of November 21st, 2021 pretty well? No, it's been a minute, but
Best as I can, yeah.
what were you doing that evening, if you recall?
The Christmas parade?
Were you marching in the parade, or
No, I was watching it.
who were you there with? Family, friends?
My wife and my daughter.
Do you recall where you were positioned to watch the parade?
I was standing in front of the Corey Insurance on Main Street.
Okay. Is that part of Main Street close to like a side street? If you recall,
Not too far from Maple.
do you recall the side streets being barricaded during the parade?
I don't remember.
Do you recall what time you arrived at the parade that evening?
It had just started, so whatever time that was at.
You recall something other than the parade catching your attention that day?
People getting hurt, yeah.
And what did you see that day, if you recall?
I saw a red SUV plow over a bunch of people.
And did you see the driver of this SUV you're referring to?
Yeah, he's standing right there.
And how many people did you see in the vehicle?
Just one, the driver.
So, do you recall flagging down a law enforcement vehicle that evening?
Yeah, I do.
And do you recall what you told the officer that evening?
Not very well.
I'm gonna attempt to see if anything brings back some recollection.
Did you make a statement? Did you write a statement?
First, do you recall the name of the officer you flagged down that evening?
Officer Moss.
Do you recall telling Officer Moss that you observed 3 or 4 people in the SUV as it passed you?
I don't remember that.
What is he trying to decide on what to say? I thought he got questions
So,
prepared.
to your recollection, the the SUV that you saw, did it have tinted windows?
I don't remember.
And do you remember what the description was that evening that you gave to law enforcement?
I told him it was a red SUV.
The description of the driver, do you remember that?
I know he was a black male.
Is that all you recall about your description?
That's all I remember.
Oh my God, he is dragging this out. He should be. You're right.
After seeing this vehicle, what did you do?
We left. I got my family out of there.
And where did you go?
We headed back to the car.
Do you recall where your vehicle was parked?
I believe it's the Lindholm or building on Maple Street.
And did you see the vehicle stop on Maple Street?
Which vehicle?
The SUV that you claim you saw.
Oh, no, I didn't see it stop. No. It kept going through the parade.
And speaking with, is it Detective Moss? Well, speaking with law enforcement that evening, do you recall advising law enforcement that you observed 3 black subjects running from the vehicle?
No, I don't remember that.
If it pleases the court, I would like to show the witness this. I'm referring to page 4 exactly.
Is it a statement this witness personally wrote?
I believe it's what, I don't think he wrote it himself.
So it's a summary written by another person.
By, I don't know if it's Officer Moss or Detective Moss. I'm not sure what his rank is.
Continue with your questions. I'm going to deny the request that you showed the exhibit or the paperwork to the witness.
Do you recall making the statements to Detective Moss that you observed one where it says 1 was described as running southbound on Maple towards College Avenue? Do you recall that?
No, I don't.
Do you recall stating that the other 2 were described as running in a westerly direction from the rear of 338 Maple Street?
No.
Do you recall stating that 1 black subject was described as tall, wearing a blue top and blue and black pants, while the other subjects were described as 2 short black males wearing sweatpants?
Barely, a little bit of that.
So, which of these subjects do you minimally recall wearing those items that evening?
No, you asked me if I remember people running, and I said no. I remember describing those people to him. I remember.
So where did you observe those?
Standing by the vehicle, where I found the vehicle, where I spotted it.
just so we have clarity, describe the subjects you saw that evening standing by the vehicle.
I don't
What were
remember
they-
that good. I mean, you were describing them, so it brought back a little bit, but I can't tell you. That was too long ago.
I like this witness, bro. Look, what you want me to do? What do you want me to do, bro? You brought me
How
in
did you
here.
come
I got
upon the
Hola,
vehicle at
Holmes.
the address of 338 Maple Street that evening?
Well, I was walking my family back to the car, trying to get them to safety.
because you decided you want to be a
I was
pendejo.
keeping an eye out, and I spotted it.
Do you recall stating that you saw the SUV reverse into a driveway?
No,
Do you recall why that would be reported?
no. When I found it, it was parked already.
Sorry, yawning. That's how boring this is. I like this witness though. No further questions.
Do you recall when you initially had the interaction with Detective Moss? Do you recall leading him to where the vehicle was ultimately found?
Yeah.
Do you recall yelling at subjects standing outside of the building where or near where the vehicle was that evening?
I remember asking them. I don't remember yelling at them.
Sorry, you all, that this is taking forever.
Do you recall why? Do you recall why the report says that you advised Detective Moss that there are 3 black subjects, specifically black subjects, running from the vehicle?
No, I don't remember.
Were you yourself injured in this incident that evening?
No.
It's all a stall tactic. Sorry.
Do you recall stating that? Well, let me back up for a minute. Did you speak with another detective that evening, if you recall?
First
Yes.
time the judge is going to step off the bench to grab some drink. Court's in
Uh,
partial recess.
do you recall if that was Detective Coates?
I don't remember his name.
So it'd be fair to say that you spoke with two different law enforcement officers that evening.
Yeah.
Do you recall in your interview with Detective Coates, in reference to the vehicle that you saw that evening, do you recall telling Detective Coates that it appeared there were 3 or 4 people in the Ford Escape as it passed you?
No, I don't remember that.
Do you recall in your
What does that even mean,
Detective
Darrell?
Coates that evening stating that you could not provide any description of the occupants other than that they appear to be African American?
Yeah, I remember saying that.
So it'd be fair to say that you observed African Americans in this vehicle that you saw, correct?
The reason why I came up with 3 or 4 people was because when I was walking by and I saw the car, there was 2 or 3 black males standing by the vehicle. There was at least 3 or 4 more on the porch. So I figured they were by the vehicle. It must have been the ones trying to hide the vehicle because they were standing in front of it or real close to it.
In your opinion, did it look like they were nervous or attempting to hide?
So everybody was running past them and walking really fast, and they were just standing around there. They were the only ones not doing much. So yeah, they stood out.
Now, this is the question actually was in reference to when you spoke with Detective Coates that evening, in reference to seeing the vehicle in the parade as it passed you. Do you recall at that point, while at the parade that evening, do you recall stating to Detective Coates that it appeared that there were 3 or 4 people in the Ford Escape as it passed you during the parade that evening?
No, I don't remember that.
Any reason why the Detective Coates would report that that's what you stated to him?
Like I said before, I saw 2 or 3 people by the vehicle, so I assumed they were with the vehicle. So they must have been in the vehicle during the parade. I saw the driver going by because he hit somebody right in front of us.
Hit somebody right in front of you, yeah?
Do you recall in your
Guilty.
interview with Detective Coates that evening stating that the 3 individuals, and I'm referring to who you saw next to the vehicle, so clarification. The 3 individuals who were standing in a line, shoulder to shoulder, as African American males?
Yeah.
So it's fair to say that's what you observed that evening?
I saw at least 2 of them.
Fruit parfait,
They were
peaches.
standing in front of it.
Hmm. Remember as a kid, used to
During
eat
that
fruit
interview with
parfaits. It was
Detective
pretty
Coates
good.
that evening, do you recall stating to Detective Coates that
you may be able to recognize the older male. So I'm assuming one of the individuals that you saw standing shoulder to shoulder was a older male.
I don't remember.
Yes. You say you don't remember, sir? Okay, keep going. You may inquire. For the record, we have given Mr. Brooks the hooked on phonics version of the notes. That's why it's taken so long.
Any
I'm
reason
sorry,
why
sir. You may inquire.
multiple? Well, I'm not gonna say multiple. Two. Any reason why the two detectives that you spoke with that night both reported that you stated you saw 3 black subjects running from the vehicle?
Objection,
No.
asked and answered. No objection? No? Okay, all right.
And during the parade incident, were you or anyone you were with injured that evening?
No.
No further questions at this time.
Will there be any other time?
Yes, Your Honor, thank you. Good afternoon, Mr. Lozano.
Good afternoon.
Sir, you said you watched the parade near Curry Insurance, is that correct?
Yeah, right in front.
Okay. Do you remember, you said you saw the SUV strike some people in the parade?
Yeah.
Yes. Do you remember what group of people in the parade? Can you remember anything about the name or the banner or the costumes or anything like that?
Objection leading.
Overruled. It's crossed.
She's allowed to cross.
No, I don't.
Speculative. Objection.
Overruled. The witness may answer. I believe he said no. His answer may
Yeah,
stand.
no, I don't remember.
Okay. Do you remember seeing the SUV strike more than one person?
Yeah.
Objection. Speculative.
Overruled.
About how many people did you see the SUV strike, sir?
Objection. Speculative.
Overruled.
It was crowds. I mean, when it was coming through, because I was standing over my daughter and my wife, they were sitting on the curb. I saw it coming through, and at first it looked like it was just pushing people out of the way, and then it just kept swerving back, and it was just plowing everybody out of the way. till it
Objection
got
to
in
the
front of us, then it-
This is where he would need to object to the
it's just-
characterization of
car was right
plowing.
there.
You remember that?
Yeah, it was right in front of us.
Okay.
And while the witness was giving the answer, not the last answer, but the one prior to that, he had his right hand in the air, directioning his hand from right to left, describing the vehicle coming from right to left. And then when he said he saw someone go into the air, he was like twirling his fingers as if to say it kind of tumbled in the air. All right, go ahead.
Thank you.
I'll tell you what he did
So,
try to do.
Mr.
I'll tell you
Lozano, I want to talk about the moment when you located this vehicle on Maple, okay? I'm going to ask, Madam Clerk, could you please turn on the AV system? We're going to put up State's Exhibit 65.
And for the record, AV stands for audio visual for Mr. Brooks. You may continue. It doesn't stand for audacious
Objection to the
Vicky.
relevancy of Exhibit 65.
Noted, overruled. It's been received. The state may proceed.
All right, this total clip is 36 seconds, but before we begin to play it, sir, do you recognize?
Madam State's Attorney, can you speak into the mic, please?
That's
Yeah.
shown in this picture?
Yeah, I believe that's Central Middle School,
Where?
right at where the stairs is.
Okay, the red brick on the left side of the picture?
Yeah.
Objection.
Okay.
Speculative.
Overruled.
Overruled. His answer may stand, he said, I believe.
And would you agree with me, the house where the SUV was found was up in this area here where I just put the green dot on the screen?
Yeah.
Objection leading.
She's supposed to. She's cross. Overruled.
You may answer.
Yes.
That looks right, correct, sir?
Objection leading.
Overruled.
Overruled.
All right, we're gonna clear the screen, please, and we're gonna play this entire clip for 36 seconds. Please watch and see if you see yourself or any of your family members in this clip.
Objection to the relevancy of this video to this.
Proof of the matter
particular
asserted. Overruled.
Overruled. You may play the clip.
Overruled on what grounds, Your Honor? Is that a tacit agreement?
Sir, did you see yourself or your family in that clip?
Objection speculative.
Overruled.
No, I did not.
Okay. Now, you said you did see, by the time you walked past the car, you saw 2 or 3 black males standing near the car, right?
Objection mischaracterization of this. He said 3. Specifically said the number.
Overruled.
And you also said you saw 2 or 3 what you thought to be black males on the porch of the residence there, correct?
Objection stated it was black males. Asked and answered.
Overruled. The witness may answer.
No,
I'm sorry, go ahead.
no, there was 2 or 3 standing by the vehicle.
Okay.
And then on the porch, there was maybe 3 or 4 more people. I don't know if they were, I'm sure they were white, but
Okay.
I was trying to not make it obvious at the time. I believe that they were with the vehicle, so I didn't want them to see that I saw them. So I just did what I
Understood.
thought was right at the time.
Sure. Do you happen to know the people that live at this house?
Objection speculative.
Overruled.
Overruled.
No, I didn't.
Would it be reasonable, do you think, Mr. Lescano, that people living in the house heard the crash and came outside and that's who you saw standing there by the vehicle?
Objection. There was never any crash mentioned.
I'll sustain. Calls for speculation.
Good one.
Mr. Lescano, is it possible that the people you saw standing near the vehicle were in fact just neighbors that saw the vehicle the same way you
There's gonna
do?
be an objection.
Yeah.
That should be an objection. Oh
You
my God.
described that at the time you went by on Maple Street, there was a lot of people running around in the area. Is that correct?
Objection mischaracterization of testimony.
Overruled.
Yes, it was.
And these are people hurrying away from the parade with their families, trying to get to safety just like you were, correct?
Objection speculative.
Overruled. The witness may answer.
Yes.
You didn't see anything like that in State's Exhibit 65, did you?
No, I did not.
You got a headache?
You said on direct examination that you saw the driver of the SUV in the parade. Is that right?
Yes, I did.
And you see that driver present in this courtroom here today, please?
Objection speculative.
Overruled.
Yes, he's sitting right over there.
Are you sure about that, sir?
Yes.
Objection speculative.
Overruled.
Let the record reflect that
You
the
said that-
witness has
Mischaracterizes
pointed to the
testimony because
in-court identification
that
of the
was not
defendant, Mr.
testified
Darrell
to
Brooks. You
before.
may continue.
Direct.
Your objections are overruled. I believe the witness already answered. Go ahead.
And she did not state on the
Did you
record.
happen to notice in Exhibit
She needs to
65
make a record of
the
the
red
in-court
SUV
identification
in
by the
that
witness.
video clip that you watched?
No.
You didn't see it at
Couldn't
all,
see
did
it,
you?
no.
Okay, just wondered. Mr. Lescano, have you and I ever spoken about this case, sir?
No.
What about Attorney Basie here to my right? You and her ever talk about this case through your testimony?
Objection hearsay.
Overruled.
No.
Mr. Witchow on the end, did you ever talk to him about your
Objection.
testimony, sir?
Objection hearsay.
Overruled.
No.
All right, thank you, sir. I don't have any other questions.
All
Can
redirect.
you redirect?
Yep.
Yep.
ahead.
Yep.
You stated that you saw
We
the
do not
driver
want to see his
correct?
balls. Thank you.
Of the SUV that you saw that day, correct?
Yes.
How did the driver look that day you saw him?
He had a scruffy beard and he was a black male.
Did you see what the driver was wearing?
No, I don't remember that.
Did you see if the driver had any hair?
I don't remember that either.
Did you see if the driver had anything noticeable about their appearance, tattoos, scars, marks, anything like that?
No. I saw the side, the profile, the side. You were flying fast down that street. wasn't paying attention to the color of clothes you were wearing. I knew it was a black male and had a scruffy beard. The first thing I told my wife is he was a black guy driving.
And do you recall how long you were able to get a side view, as you called it, of the alleged driver?
Well, it had to be a couple seconds.
And in a couple seconds time, you were able to make out the driver's profile and race just by a couple seconds.
Yeah. It's not hard.
Like you want to whoop his ass.
You can tell if you were white or if you were black. And if
Trying
you had a
to
beard,
say if I'm lying,
what
Holmes?
color shirt you had
I'm trying
on.
to say if I
You
like.
had hair, a hat on backwards.
So that leads back to the question of
His
is
faces.
that the only person you saw in the vehicle?
From what I remember, yes, I saw the driver. Like I said before, the reason why I thought there was 3 or 4 because I saw 3 or 4 people around the vehicle when I spotted it.
So would it be
That's the only reason.
Would it be fair to say that when you spoke with 2 different detectives that evening, the evening of the parade, both of those officers reported that you stated there were 3 or 4 people in the SUV as it passed you? Is that fair to say?
Oh, wait, can you repeat that again?
Please.
Just for clarification, you already stated previously in testimony that you spoke with 2 different detectives that evening, correct?
Yes, I did.
And both detectives that you spoke with that evening, the evening of November 21st, 2021, you stated to both of those law enforcement officers, detectives, that you observed 3 or 4 people in the SUV.
Like I said before, the reason why I said there must have been 3 or 4 was because they were standing by a vehicle. So I assumed that they were with the vehicle. I don't remember seeing them in the vehicle when you were hitting the people.
You stated this to both detectives, 2 different detectives, the evening of November 21st, 2021. And this was in relation to what you saw from the vehicle at the parade, not where the vehicle was later found. Any reason why you stated to both detectives in relation to what you saw at the parade, why both detectives in their reports stated that you told them that you observed 3 or 4 people in the SUV at the time of the parade?
So what's your question?
The question is, why did you report that to 2 different detectives on the same evening?
Like I told you before, when I walked past the vehicle, I spotted more than one individual standing in front of the vehicle. So I assumed they were with the vehicle. That's why I said they were inside.
I'm sorry.
That's why I said they were in the vehicle. I said there had to be at least 3 of them in the vehicle. That's the only reason I said that.
So why would you report that you saw this during the parade?
I don't know.
And during both interviews with detectives that evening, the evening of November 21st, 2021. You also stated to both detectives that you observed 3 or 4 black or African American is the word used. 3 or 4 African Americans running from the vehicle. Any reason why both detectives reported that you said that?
No, I don't remember.
No further questions.
Thank you, sir. You may step down. We have additional witnesses here.
Yes, Your Honor, they're ready.
All right, would that be how many people?
There's 2 left.
Okay, so the 2 left on your list, your next witness, sir.
So I'm guessing that's, oh, I know who it is. Just give me 1 quick second, Your Honor. 1 quick second.
Go ahead.
All right. So while we're giving him a quick second, take a moment to share this, like it, comment, please. Go grab a fruit cup, something cold, something new, something hot, something blue. I object. There you go, Melissa. That's it. Get something to drink.
Sorry about that, Your Honor. I'm just making sure I have the correct paperwork.
My jurors need to stand. Go ahead.
Oh boy.
This is what I was looking for. So much paperwork.
So much paperwork. I cannot get over the face. Oh God. He's taking so much time. So much time. Shabba-la-la-la-la-la-la. La 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 la. La 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 la. And it blanked out. I don't know what happened. I didn't pause it. I guess it blanked out. I don't know what happened. Oh, okay. La 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 la. Let's keep it going. Maybe it'll hook back up. Oh, I didn't pause it. It's still going. See? It's probably the best action we've gotten thus far. The court seems to be bending over backwards to give him all kinds of extra privileges. If he chose to represent himself, we already know that he has a fool for a client. Yes, very much the case. But you don't want the case to be overturned on appeal. Okay, you don't want that. And so, all right, here we go. I leave it to you all to decide. Do you want to still watch it, or you want to pull the plug and maybe watch some highlights a little bit later? Because the court is ready to adjourn for the day and do some other stuff. Oh, so type in number 1 in the chat if you want to adjourn. Type in number 2 if you want to keep going. 1 if you want to adjourn. 2 if you want to keep going. And be honest. Don't do it for me. Please don't. Do it for you. 1 if you want to adjourn. 2 if you want to keep going. I'm waiting for the 2. Look at y'all. Look at y'all. 2 want to keep going. All right. Well, then we going to keep on. Oh, all of y'all number 2. Well, let me see if we got another feed. All right. Look at y'all. All right. So we got to find another feed then. I don't know if I want to go. We the jury find in favor of 2. All right. All of y'all said 2. Okay. All right. We're going to keep on going. I will not disappoint. All right. Let me just push here. Pop. Find another. Law and crime. I am not going to use Law and Crime's feed. They are not fans when people use their stuff. Oh, we might be back up. Are we back up? No. Might have to use court TVs. Or, oh, so that's the court. Everybody is at that same card. Yeah, everybody's at that same card. Including, I believe, Law and Crime.
It's
No,
Until
Law
9
and Crime
of
is
the
up.
Children went by.
do you recall where you were positioned during watching your?
See, I kind of don't want to use theirs though.
Yes, on north and east, right on the corner there.
Damn. We might be SOL. So here's the reason why I don't want to use Law and Crime's feed, because Law and Crime is good for. Okay, I found it. I found one.
He doesn't want it published, so just.
And it's another news station.
Just I want to make sure the witness.
No, it's another news station. We're good. Law and Crime feed is good for doing copyright strikes.
Can you see that on your screen yet?
I do.
And using the touchscreen, it's a touchscreen. Can you point out where
It's not published. So do you want it published?
I'm sorry. Yeah, published.
Sorry, I didn't mean to interrupt, but I just wanted to point
So
that out.
just so I know, to use the touch, it has to be published.
No, she could use it, but if you're gonna have her do it, it should be done in front of the jury.
Fair.
Okay, go ahead.
I think we got to wait on the jury, right?
Thank you.
For the jury, and can you, using the touch screen on your screen, can you point out exactly where you were positioned?
When I was watching it,
Yes, when you were watching.
right on the corner. Sorry. Oh, well, if you want to
Can you clear?
erase it
Can you
again,
clear
I'll do it
the
again.
arrow?
We'll clear it. You can do it again.
Okay.
If you don't want, do you want the arrow?
Well, it was to the
Clear it again.
Okay.
So it's a touch screen, so use your index finger and you can draw a circle.
Okay.
I was gonna
Can you
say
clear
that.
Well, I mean, it was right there, but
I was gonna say a circle or a little dot if.
well, I thought I would do that. but-
Yeah.
Oh.
Hold on.
Heavy
We'll do it
hands.
again. So press and hold while you draw.
Okay.
There you go.
And
You said that would be approximately East Main and Northeast.
Correct.
And do you recall if those will there's side streets right there that you can see? Is that fair to say?
Correct.
And those side streets would be Northeast and Buckley, correct?
Promise I
Correct.
didn't.
Do you recall if there were barricades at those?
I can't honestly recall. I can't be sure.
We can take Exhibit 15 down.
Thank you. Go ahead.
And you said you stayed at the parade until your group had passed.
Correct.
And what time did you leave?
I can't determine the time. It was right after my group of kids went by.
And where'd you go from there?
I walked down, well, I went to go get the car because I had to go pick them up at the end of the parade.
And I'm assuming at some point your attention got drawn to something happening. That'd be fair to say?
Not necessarily.
What do you remember when you went to go get the vehicle to pick up members of your group? That'd be fair to say first? I don't want to assume.
Yeah.
Do you recall anything happening at that point?
A situation did occur before the said big event that took place.
What do you recall happening at that time once you were on your way to get your vehicle?
I think I need more specifics from you to give the details you may be looking for.
While you were getting your vehicle, did you observe anything happening? Did you overhear about anything happening at that point?
Nothing of that nature. Well, all I can say is that I was walking past White Rock.
Did you see anything that may have alerted your attention at that time?
Yes, a car coming through the parade at the beginning on White Rock where the parade was starting. So when I left, I walked down Main to White Rock on the corner there. Then a gentleman, a child who I don't know who they were, and myself walked across the street. And at this time, a car was beeping and weaving around a slight curve that White Rock has, and then continued on.
Did you see did you see where the car went at that point?
Yes, I did. As it came around the slight curve White Rock has, it started to move forward, and then it went straight across when I was thinking it was going to leave the parade route. If you leave the parade route on Main, you're leaving. Sorry, if you turn left, you're leaving the parade route. If you're turning right, you're going right into the parade. And it went right to if you're looking at the parade, it was on the right-hand side. And it's continued on into the parade.
Hold on, just for the record, she was using her hands
Yeah.
during her testimony. That's okay. I just need to make a
Yeah.
record of it. Usually her right hand just kind of demonstrating the course of travel that she described, the vehicle. And I think that's probably all I need to put on the record.
Sure.
Go ahead. Next question.
I want to back up a little bit. When you first observed this car, as you say, you recall that it was blowing its horn.
Yep, the horn was beeping.
Do you recall if you saw who was operating that vehicle?
Unfortunately, sir, I can't recall.
Do you recall if you might have seen multiple people in the vehicle at that time? Or?
Unfortunately, due to the time passing, I cannot recall.
That's fair. It has been a while. Do you recall about what time that was that you observed the vehicle?
Again, I can't be sure.
Sorry if I keep asking.
No,
you stuff.
I can't be sure. I'm sorry.
At the time that you observed the vehicle, did you see it strike anyone?
I did not, or at least I don't recall. I'm sorry.
And do you recall if the vehicle was speeding at that point that you observed it?
It wasn't speeding, but it was, all I can state is it wasn't speeding.
Did you happen to catch the license plate number of the vehicle at that time?
No, not at all.
Do you recall if the vehicle had any tinted windows?
I couldn't recall. I'm
Any
sorry.
windows rolled down or up at the time you observed it?
No, unfortunately, I don't remember.
Do you recall if the vehicle passed close to where you were walking at the time?
Yeah, it was close enough that it could have easily have had clipped me or the two people that were in front of me.
Where you were, the two people that you referred to in front of you, were any of you hurt at that time?
No.
No further questions right now.
Hey, Cross.
Yes, thank you. Good afternoon, Mr. Bell. Thank you for being here. You testified on direct examination that you don't recall whether or not you saw more than one person in that vehicle we're talking about. Remember saying that?
Yes.
You remember meeting on December 2nd,
No.
2021 for
You
an
won't be
interview
able to
with
say that,
Detective
Amber.
Jay Carpenter from the Waukesha Police Department?
I remember going as to a lot of topic of conversations. I unfortunately can't recall those too clearly.
Do you remember telling Detective Carpenter that you only observed a driver in the vehicle?
Jason,
It's on cross, he can't.
Overruled, you may answer.
I can't be too sure.
Overruled, you may answer.
Can you say that again? I'm sorry.
I can't be too sure. Again, some of the conversations I may have had that day.
Do you remember what this vehicle looked like?
I do not.
Do you remember telling Detective Carpenter that it was a red truck?
I do not.
Can we please put up for everybody Exhibit 15 again?
Go ahead.
Can we zoom in on the intersection of East and Main?
Go ahead.
All right, thank you. Your testimony is that you were standing here on the northeast corner of Buckley and Main Street. Is that right?
Correct.
Objection already answered that, asked and answered.
Overruled, you may answer.
You said correct.
Correct.
And after your children walked by in the parade, you walked in this direction towards the intersection of White Rock and Main. Is that correct?
Objection
Correct.
leading and speculative.
Overruled as to both, you may answer. If there is another objection, just.
I'll
wait
pause.
until I rule on it. Oh, that's okay.
Correct, that was.
And then you crossed through the crosswalk on the north side of Main Street. Is that correct?
Yes.
Is that when you saw this vehicle we've been talking about?
Yes,
So you were standing in the crosswalk.
correct.
Do you remember a police officer being in that intersection?
I can't be too sure.
Was it clear to you that this was a parade route?
Yes, it was very clear.
Was it clear to you that traffic from White Rock should not have driven onto Main Street
Yes,
unless they were part of the parade?
yes,
Did it appear to you as though the vehicle we've been talking about was part of the parade?
No.
How many children do you have, Miss Darrell?
Objection irrelevant.
Overruled. You may answer.
4 children.
All 4 of your kids were marching in the parade that day, weren't they?
Yes.
Objection leading.
Overruled.
He's allowed. And this is his witness.
Your
His
oldest
witness.
daughter, Charlotte, she was 14 at the time.
Yes.
She was marching with the extreme dance group as an alumni, wasn't she?
She was handing out candy.
Objection.
There was an objection, it's overruled.
I didn't even state why I was objecting, but okay. We still need a 15.
Yes, please. You see on that map the 5 points intersection?
Yes.
When you were standing in the crosswalk at White Rock in Maine, could you see the 5 points intersection?
I could not.
You didn't see your kids get hit, did you?
I did not.
Objection leading.
Sorry.
Overruled.
Okay, I'm sorry.
Objection hearsay.
Overruled.
You didn't.
I did not.
Did you see them later that night?
Objection leading.
Overruled. You may answer.
I was only able to see 2 of my children that night.
When did you see the other 2?
Days later, when I was able to leave Children's Hospital.
As their mother, you were directly involved in their medical care, the decisions that were made in that process in the days after the parade?
Objection leading.
Overruled. You may answer.
Yes, their father and I.
Charlotte suffered a chipped vertebrae from being struck, didn't she?
She did.
Objection
Sorry.
leading.
Overruled. You may answer.
She did.
Your daughter Alice, she was 10 at the time, wasn't she?
She was.
She suffered chipped front teeth, is that correct?
Yes.
And facial scarring
Yes.
and road rash
Yes.
and a broken fibula and tibia
Yes.
and broken metatarsal bones.
Yes.
Objection to
She was
Tyrannosaurus
observed in the
bones.
Concussion protocol, is that correct?
She was.
Your daughter Vivian, she was marching with the extreme dance group too, wasn't she?
Yes, she was.
How old was she in November of 21?
She just turned 7.
Vivian suffered a severe concussion, didn't she?
Objection leading.
Overruled. You may answer.
Yes.
And road rash
Extreme road rash.
and a lung contusion
Yes.
and facial scarring.
Yes.
And your 7-year-old daughter Vivian suffered a broken tailbone, didn't she?
She did.
Your son Grayson, he was 8 on November 21st, 2021. Is that correct?
That is
Objection
correct.
leading.
Those are real tears.
He was walking with the extreme
Oh,
dance group,
Lord.
handing out candy. Is that right?
He was.
He went to the hospital after the parade, didn't he?
Yes.
He suffered a compound fracture in his femur. Is that correct?
An open compound fracture.
Meaning the bone came through the skin.
Yes.
Objection hearsay. I don't believe he's a doctor.
Overruled. The witness may answer based upon personal knowledge.
Is that a yes?
Yes.
A police officer saved Grayson's life by placing a tourniquet on that open leg wound. Is that correct?
Yes.
I don't have any other questions.
Can you read the record?
You better not redirect. You better not redirect. Let it
No
go.
redirect.
Thank you. Whew. Smart decision on him not to redirect.
Let me call your next witness, please.
So we're gonna take down these exhibitors. You're gonna stay up on there.
Thank you. We'll take it down. Please call your next witness.
Just 1 second.
Oh no. Oh no. Oh no. It's not me. Right. No, I got it, James. I'm not going nowhere.
So you want my person here, right?
It's my understanding, sir. Would that be correct, Attorney
Yes.
Upper?
Yes, she's in the courtroom, ready to go, Your Honor.
Defense calls Catrice. I don't know how to say the last name.
Can you give me the spelling that you have?
Babias.
Babashi?
Like it's Fabias? What's your last name?
Fabias.
Fabias. All right. Thank you. You are at the witness stand.
Hey,
Please raise
asshole.
your right hand. My clerk Teresa will swear you in.
Boy,
solemnly swear that the testimony you're about
you
to
better not
give
butcher her last
shall be
name.
the truth and nothing but the truth, so help you God.
Thank you, ma'am. Please have a seat. First thing I will ask you to do is to state your first and last names for the record and then spell each.
Catrice Fabias, Katrice Babiazz.
Thank you. My apologies for mispronouncing that earlier. Go ahead, your witness.
Good afternoon, Miss Fabias.
Correct.
I'm surprised I got it right. What do you do for a living?
I am a law enforcement dispatch supervisor.
And how long have you been doing that now?
I've been in law enforcement for 16 years.
The evening of November 21st, 2021. Were you on duty that evening?
I was not.
What were you doing that evening?
I was attending the Waukesha Christmas parade with my family.
And do you recall what time you arrived there with your family that evening?
I arrived to the parade shortly after it started, so it was right after 4 p.m.
And do you recall where you were positioned at with your family when you arrived at the parade that evening?
Yes.
And where were you positioned at?
I was towards the beginning of the parade. I was on Main Street where it connects with White Rock Avenue.
Did anything catch your eye that evening when you were positioned watching the parade with your family?
Yes.
What did you see?
I saw a red SUV coming from White Rock Avenue The vehicle caught my attention because people started yelling, and the driver was honking the horn.
And do you recall, to the best of your knowledge, it's been a little bit, the driver of the vehicle you observed was honking his horn. Was it gesturing to people?
Yes.
And what do you see? What did you see the gesturing as?
I'm sorry, I don't understand the question.
What was the gesturing?
What was the driver gesturing?
Yes. I'm sorry.
It's okay. So he was taking his hand and going like this, really rapidly, aggressively.
So for the record, the witness had her right hand up above, probably above her, I wouldn't say at a 90-degree angle, but somewhere maybe at a 45-degree angle with her hand waving back and forth multiple times in a rapid motion. Go ahead.
You yourself being in law enforcement and just based on what you were observing, the driver of the vehicle you observed was honking his horn and gesturing with this motion. Would you take that motion as trying to alert people to move out of the way? Grounds.
Sustained is to the form of the question. Please rephrase.
How did you yourself take that gesturing?
I took that gesturing as the driver was telling people to get out of his way.
Let me back up. Did the vehicle pass pretty close to where you were positioned?
Yes, the vehicle almost struck my daughter.
Do you recall seeing the driver?
I looked the driver right in the eyes.
And how did the driver look?
The driver looked like through me.
Like, what do you mean through you? Describe what you mean by through you.
I feel that it is very hard to explain that look, but it was very frightening.
Do you recall what the driver was wearing?
The driver had a hoodie sweatshirt or sweatshirt on, and something on his head. I wasn't sure if it was the hood of the sweater or maybe a beanie hat. It was winter. I'm not 100% sure.
Were you able to see any hair?
I did see hair, yes.
How would you describe the hair?
The hair on the head was in front, like dreads down here from what I could see underneath the hood or the hat. And then there was facial hair, beard and mustache.
Did the vehicle?
Hold on, I just need to make a record of, she was also using her hands, that's okay, to indicate at the neck, like under the chin, neck area, with her hands coming down a few inches to indicate what she was describing as hair being seen from the driver. Thank you. Go ahead, sir.
When you observed the vehicle approaching, was the vehicle speeding?
When the vehicle was approaching from White Rock, the vehicle was not speeding at that time.
To the best of your knowledge, do you recall there being any barriers present where you were positioned at?
Yes.
We're not laughing at her comment.
Do you recall if the vehicle you observed had any tinted windows?
I do not recall.
Were you able to make out a license plate number of the vehicle, being that it had passed so closely by you?
No, once the vehicle continued past my position, I was more concerned about my children that were with me.
I'm assuming at some point you spoke with the law enforcement about what you saw that evening. Would that be fair to say?
Yes,
And do you recall what agency that was?
I do.
And what agency was that?
The FBI.
What does FBI stand for? I was told it was female body inspector. No, you can't say that? Okay, keep going. All right.
At what point were you not able to see the SUV once it passed you?
I lost sight of the SUV once it went into a bunch of people.
Do you recall what date it was that you spoke with the FBI agents on? Was that the same evening or a few days after?
It was not the same evening of the parade, but it was that week. It was within the next few days.
The day you spoke with FBI agents, do you recall stating the driver was wearing a red top that appeared to be made out of a sweatshirt-like material?
I don't recall exactly what was said to the agent, but I do remember the sweatshirt, yes.
A red sweatshirt?
It's possible.
They're gonna COVID Larry again. Y'all, y'all better stop.
Just a little bit ago, you said that, well, when asked the question of did you recall hair for the driver, you stated and made the gesture that the hair was in front. Do you recall saying that?
Yes, sir.
Do you recall
He gets a whole
when speaking
sir?
with FBI agents
Wow.
stating that the hair was pulled back?
The hair appeared to be like possibly in a ponytail, but it was so full that it was coming forward.
Would you say it was like Prince Ragu's Spaghetti Wednesday type hair? That's not a valid question. I'm sorry, Mr. Brooks, you may inquire. Why are we all still waiting for you? Oh my God, this is.
Do you recall? Well, let me back up.
Cross-examination is
Did you
towards
leave
the,
the parade at that point
just direct examination.
At what point?
after seeing the vehicle?
Yes.
Were you injured the evening of the incident?
Yes.
You were injured?
Yes, I was.
Any reason why that's not reported?
You were injured? Shit, I didn't know. I didn't know.
Probably because I didn't tell anyone else.
Yes.
If you were injured, why not tell anyone?
Objection. What? No.
Because
no,
I
no.
haven't wanted to talk about the traumatic experience that I went through for still reliving the weeks and days after the incident.
It doesn't make any sense. You talked to FBI agents a few days where you said you didn't, to be fair, you said you didn't know. You said it was that week, is what you said. The same week. You spoke with FBI agents, reported no injury.
They didn't ask me about injuries.
Well, would it be fair to say that kind of information would come up when talking to law enforcement, seeing as how you yourself work in law enforcement? It just seems odd, don't you think?
I do not. I was not physically injured.
Oh.
Oh.
But you didn't report this at any time whatsoever. Grounds.
Sustained. Already answered.
So did you speak to anyone about this in law enforcement?
Objection made.
Grounds.
Overruled. She may answer. He clarified law enforcement. Did she speak to anyone about this in law enforcement? I interpreted this as the injury.
Right.
So go ahead.
I feel like, no, I did not.
Did you file any claims related to the incident?
No, I did not.
We need to take a stand break. It's been a minute since we had one of these.
So today, your first time bringing up your alleged injury?
No, it is not.
Thank you, Josie Blue. Thank you. 2 children's books. By the way, if you guys appreciate the live stream, Please donate $5 to my Cash App or PayPal for these kids' books. It's streaming across the thing. You don't have to if you want to. I would be humbled. Thank you, Josie Blue, for that.
At some point, you were
Appreciate you.
subpoenaed by the district attorney's office to testify here to testify in this trial. Would that be fair to say?
Yes, it is.
Do you recall when you received that subpoena?
From the district attorney's office, it was in July.
And do you recall whom you spoke with about the information?
I will post the links right here. I will put the link
I
in
contacted
the
the
chat.
victim witness advocate, Carrie Peterson.
You contacted the Ms. Peterson after receiving the subpoena.
Correct. The instructions told me to.
Thank you, James. I appreciate you. I just put the links right there. I'm going to pin it in the live. Ew.
You ever spoke with anyone directly at the district attorney's office?
No, Josie
No.
Blue. Yeah, I don't have super chat. My
Correction.
page can't be
Yes, when I
monetized,
walked
but I
in
appreciate
today,
you.
I met there
We
and let them
deal
know I
with
was here,
violent topics.
and then they walked me into a room, and I waited until I was called by you.
So before today, you had no interactions with anyone.
Yeah, I got
related to
PayPal and then the Cash
district
App is
attorney's
right there.
office besides I think you said victim advocate.
So the victim advocates who have been in connection with and letting me know when to come and all of that.
Of the three district attorneys seated to my left at this table, had you had any interactions of any kind with any of those three district attorneys?
I have not.
Objection.
And I believe, just for the record, when you asked that, Attorney Basie was just pointing to herself and the two people next to her, so it's clear, because since there's two tables.
What would be the reason for that?
Since there's two tables of individuals, I think she wanted to make the witness aware. And I just wanted to point it out for the record since it happened.
His faces are so animated. That's crazy.
Working in law enforcement for 16 years, I'm sure this isn't your first time being involved in a trial. Would that be fair to say?
I have not been in a trial for law enforcement. No, I have not.
You've never witnessed a trial, sat at a trial, been in a trial?
I have not.
She's not a police officer.
Have you ever testified in any way before today? Rounds.
Overruled, she may answer.
I have testified before, yes.
So it would be fair to say that you would have knowledge of where an alleged defendant and the district attorney would sit in the courtroom, correct?
I know where they're sitting, yes.
Want to back up a little bit to the observation of the vehicle the evening of November 21st, 2021. While you observed the vehicle approaching your position, did you see it strike anyone?
I did not see the vehicle strike anyone, no.
From your opinion, observing the vehicle approaching your position,
did it appear that the vehicle attempted to strike anyone?
Yes,
And why would you come to that conclusion?
because I saw an officer have to jump out of the way in order for
When
the,
it was approaching,
when it was.
Let her answer the question.
I'm
Hold on,
confused.
hold on, everyone.
Thank you, Mia.
The
for the
question was
Cash
asked,
App
this
donation.
witness
Appreciate
is
that.
going to be allowed to answer the question fully without interruption. Go ahead and answer the question.
Thank you. I misunderstood him's question, I guess.
Answer
Did you
the
say
question
him's
that
question?
you understood.
Yep. So I saw that an officer have to get out of the way. And he was attempting to stop Mr. Brooks from driving through the parade, and he was at the last minute jumped out of the way from the vehicle. Otherwise, he would have been struck.
you just used the name Mr. Brooks for the first time that you've been testifying. Would that be fair to say?
I don't understand your question.
You just used the name Mr. Brooks for the first time since you've been testifying. Is that fair to say?
That's fair to say, yes.
Why haven't you used that name before? You've been up there
Because you don't
for
want to be
quite some time.
called to that.
I didn't need to.
So what changed for the last question?
Oh, objection. I mean, it's
I don't
not really an
understand your
objectable thing. It's just
question.
irritating.
You just stated that you didn't mention the name before because you didn't need
Asked
to.
and answered.
So what about the last question that you answered made you feel like you needed to use the name for that question and no question before that?
I don't know.
It's not helping this case. Right. Her face is not helping her case. Now, I think they're not objecting on purpose either. I think they're letting him dig his own grave.
Out of curiosity, how did you come to the knowledge of that name?
It was on the subpoena I received last week.
You just stated a little bit earlier in testimony that you received your subpoena in July. Now you said last week.
Those are both correct.
So you received two separate subpoenas?
Correct.
What was the difference between the two?
One was from the district attorney's office and one was from you.
Be like
So
obvious.
the one that you received from the district attorney's office in July didn't have a case caption on it?
Okay, what's a case caption?
Just 1 second. 1 second, Your Honor.
Your Honor, I'm just gonna object to this line of questioning. I really don't know what the relevance is for the purposes of this trial.
There was no objection at first.
Well, there is one now, and we're going to honor it.
I'm going to sustain
Thank
the
you.
objection under 906-11. I don't believe it advances.
I think
The trial.
I think you know where I was getting at with the question.
Then you need
You
to ask
don't?
the question directly, sir. Go ahead, but I'm sustaining it as to the form of the question.
Hey, Robin.
When you were subpoenaed in July by the district attorney's office, the subpoena didn't contain
information to the case you were being subpoenaed for?
Objection to relevance.
Grounds.
Relevant.
Sustained, you don't have to answer that. I sustained the objection on that, those grounds. Ask the question, I believe that you're trying to ask, not that one.
Was the name that you mentioned, Mr. Brooks, anywhere on the subpoena that you received from the district attorney's office in July?
Yeah.
Objection, relevance.
Grounds.
Sustained.
Grounds for the sustained. That was
Not
Relevance. I mean, yes, the name is on there, but she won't answer that now.
mind-boggling.
You triggered the hell out of him.
Sir, in July, when you received your subpoena from the district attorney's office, were you even aware what you were being subpoenaed for?
Objection, relevance.
Grounds.
Sustained.
Sustained.
At,
Not relevant.
She's testifying in the trial, and it's not relevant that she got subpoenaed?
no,
Mr.
just your
Brooks, she's
question is
here
not
under your
relevant
subpoena.
to the matter at hand.
What?
You called her as a witness. It's
The
your
subpoena that you, the subpoena is relevant because she
Mr.
was
Brooks,
already
under
subpoenaed.
90611, please ask the witness
This
a
is
relevant
mind-boggling.
and probative question.
This is mind-boggling. Mind-boggling.
Remind the jury that the statements of the parties or the attorneys are not evidence.
What did he just say?
So were you aware that it was a chance you would be possibly testifying in this trial?
Yes.
And did you know who the trial was for?
Objection.
Grounds.
Sustained.
Grounds for the
relevant.
sustained.
It's not
I've
relevant.
never heard of nobody testifying in a trial that they didn't know who the trial was for.
Mr.
I think
Brooks,
that's
I'm
very
sustaining the
relevant.
objection under 90611, and I'm asking you to move on.
No, it's ridiculous, man.
Oh,
Seems to me like a like a lot of your answers are coached. Is that fair to say?
No.
So the subpoena that you got last week, is that how you learned the name that you used?
Objection,
Grounds.
relevance for the same reason I argued. before.
Grounds.
Asked and answered.
that would,
She's
yeah.
indicated the answer already. 90611, sir. Next question.
The question
Different
was,
topic.
is that the first time that she saw the name?
It's not relevant.
That
Next
was not
question.
asked and answered. That was not asked nor answered.
Under 90611, please ask a question, sir.
Man, what is y'all people trying to pull up, man? This is ridiculous.
Mr. Brooks, if you don't ask another question that's relevant and probative under 90611, then I will turn the witness over to the state for their cross-examination.
And then I should be able to get redirect, right?
Technically, yes. Technically, yes. He does get redirect. Direct, cross, redirect. I mean, he's right.
Or I will
He does get redirect.
examination by you to be ended.
It's not an examination, it's direct.
It's a direct examination, sir. Under 90611, you are directed to ask a question, or I will
I
ask
heard,
the
I heard
state
you.
if they
I
have
heard
any
you, Your Honor.
questions.
I heard you. I heard you.
Thank you. Next question, please.
Shanice, ask it. I need to put this face back up here. That's why.
You know who the plaintiff is in this matter?
Yes.
Who's the plaintiff?
The state of Wisconsin.
Is that an entity or a living human being?
Objection.
Grounds.
Not relevant.
Sustained.
Next question.
Have you ever had any interaction with the plaintiff?
Objection. Sustained.
Sustained. As to the form of the
Have
question.
you ever had any interaction with the state of Wisconsin?
Do not answer that question. Next question, sir. Under 90611.
Was there an objection or was that just a ruling? I'm not sure. You're both was talking.
She should have let the state object
Under
so that she could
90611, I
sustain it.
directed the witness not to answer that irrelevant question. Ask your next question.
He has
sir.
done that so many times for every witness. What is he doing? Oh my God.
Mr. Brooks, ask your next question.
I'm gonna get to it.
Thank you.
Oh. They zoomed in his face. Oh my God. This is the
So when did you first report your alleged injury?
the state.
You do not have to answer that question. Next question, sir.
Grounds for
911.
11. Sub 1, sub A, sub B, and sub C.
Right. That's what I just put on the screen, y'all.
is that
90611.
lawful law?
All right. You may sit down. Does the state have any questions for this witness?
Like, should we? Should we? Should we? No. The district attorney's like, no, just let it rest. Let it rest. We don't have shit else. Not for them, because he's digging a hole himself. Look at
Ma'am, that day on November 21st of last year, you were there with 2 kids?
I was, yes.
What were their ages on that date?
Objection.
3
relevancy.
and
Overruled.
Overrule, the witness may answer.
Of course it's gonna be overruled.
3 and 6.
And I don't know, Mr. Brooks can sit down and can I ask any questions right now?
I
Mr.
am.
Brooks, please sit down. Mr. Brooks, you're not asking the questions.
I'm not saying
I would
anything.
ask you to sit down, please. It is disrespectful to this witness and to the state and to the court.
No, it's not. Not doing anything wrong. I'm just
Oh
really
my
standing.
God, dude. Oh.
And when you were at the parade on November 21st of last year, approximately where were you watching the parade from?
Asked and answered objection.
Mr. Brooks, it's cross-examination. Just because you asked the question initially and she answered it does not mean the state doesn't get to follow up on it.
So the state can ask the same question I
The
asked.
state can ask their questions.
So how
Go
come when
ahead.
I did that,
Overrule,
it was
the witness may
it was
answer.
sustained?
Oh, here's what I have to say. The judge,
I was on
though she's getting
Main
slightly
Street, but
irritated,
right
let
by
him object.
where the
If you're
intersection
rolling, keep it
of
going.
White Rock, and I was in the roadway.
I'm going to show you what's been marked and previously admitted into evidence as State's Exhibit 15.
Go ahead.
And I'd ask that the screen be cleared. And ma'am, does this show?
Wait until it's in the jury
I'm
box.
sorry.
I'm sorry. The jury would let me know when it's there. Thank you. It's there now. Go ahead.
Ma'am, do you see a purple line on that would indicate the parade route going from White Rock Avenue down Main Street?
Yes, I do.
And can you approximate where you and your kids were watching the parade?
Yes. Do you want?
If you, I'm sorry, it's a touch screen. I keep forgetting to say that. Touch screens, just put a dot right where it is. Okay.
Maybe on the other side of that red line?
So, okay, can we clear the screen and maybe just put a dot? I think that, or a circle. I think a circle would be good. Okay, thank you. Would be fair to say is to your left would have been Pleasant Street?
That is correct.
Were there barricades blocking Pleasant Street?
There were
Objection, asked and answered.
There were barricades that were partially black. They were on Main Street, but partially blocking Pleasant Street as well.
Could a car have gone down Pleasant Street?
Yes.
Objection.
Overruled.
The witness may answer. It's not hearsay.
So when the red
Hearsay.
SUV came down White Rock Avenue and was making its turn onto East Main Street, as you testified, it could have just gone straight onto Pleasant Street, correct?
That is
Objection.
correct.
That's hearsay. She's speaking as
Hold
first
on.
eyewitness,
There's an
first-hand
objection.
eyewitness.
Mr. Brooks, your objection is noted. It's overruled. The witness may
usual.
answer.
It's always overruled.
Go ahead, you may answer me.
Sorry, there's a lot of talking. Your question was, just to clarify, could the vehicle have gone straight onto Pleasant Street? Is that right?
Yes,
Okay, yes.
thank you. And where you stated that you and your kids were partially in the roadway when the red SUV came through?
Yes, we were.
Objection.
And
That's mischaracterization of what was testified to.
Overruled. The witness may answer. Go ahead.
Give me an answer.
Can you repeat it?
Sure. Were you and your kids all in the roadway when the red SUV went through?
Yes, we were.
Okay. You weren't part of the parade, correct?
We were not.
Okay. So were you standing with other people that were in the roadway?
Yes, we were.
And was one of your kids going to get candy when the red SUV came through?
Yes, my
Objection.
daughter.
Speaking as a first-hand eyewitness.
Overruled.
Because she is a first-hand eyewitness.
Thanks, James.
The objection is noted. It's overruled. The question is proper, and the witness may answer.
Yes, my daughter was further in the roadway. We were all in the road, but she was further in the roadway, reaching to grab candy.
At any other time, you stated that this was towards the end of the parade. Is that correct?
Yeah, we saw Santa, and he's always like the end of the parade.
And had your daughter gone to get candy at other times?
The entire time.
Had she, during the time preceding the red SUV coming through, had she almost been struck by any other participants in the parade?
No, she was nowhere near like where the vehicles were driving through the parade. She was no.
So she's going out to get some candy that had been thrown, I assume, correct?
Yes.
And
Overruled. The witness's answer may stand.
and you see this red SUV coming. Is it coming from your right or from your left?
The red SUV was coming from my right side, which was White Rock.
You're right, Tabitha. We did.
And how close did it come to your daughter?
It was, I wouldn't be able to give an accurate judgment, but it felt very, very close.
Had you not pulled your daughter away, would that car have hit your daughter?
Objection. Speculative.
Overruled.
It's very possible.
Based on her experience.
So you say that you saw a police officer have some contact with the red SUV. Do you recall that?
Yes.
Can you describe that for the jury?
Well, there was a few times
That could be an
police
objection.
officers attempted to stop
They would have liked to
the
overrule that.
red SUV. The first one was Ben, where we were on Main and White Rock. And then there were also other people trying to stop it too. And then again, as it drove, once it turned onto Main, the next road, I believe is Buckley. And there was another officer who tried to stop that red SUV again.
And which is the officer who had to step out of the way in order to not get hit by the red SUV?
What was the question?
Where was the officer located who had to step out of the way to avoid being struck by the red SUV?
I believe that was the officer around Buckley and Maine.
And ma'am, as the car passed your location, did it increase its speed?
Yes.
Do you know where in the roadway it traveled down?
Overruled.
Overruled.
She's
The
speaking to her
witness may
experience.
answer.
The direction of travel?
Where in the road? Was it on the left-hand side, the right-hand side, or in the middle?
It was all over the road.
You saw it all over the road?
Yes.
So going, and why don't you
Dri-
describe for the jury what you saw?
Driving the vehicle, once it turned onto Main, it drove side to side, and then I lost sight when there were through the people as it got down the hill.
Nothing further.
Thank you.
Redirect.
Let me read the rest.
Oh God. Here we go. Oh shit. Was there candy corn in the middle of the street? And how does candy corn react to tire
You
tracks?
said you observed multiple officers try to stop the vehicle. Is that correct?
Yes.
You described one that I think you said it was Buckley, right?
Yes.
Why didn't you report the other officers that you allegedly saw attempt to stop the vehicle?
What?
I don't know what you're asking.
Yeah.
The report that the interview that was conducted with FBI. That was who did your interview, correct?
Yes.
Why is it not in the report about the multiple officers that you say you saw attempted to stop the vehicle?
I don't know why it wasn't put in the report.
Do you recall if you told the FBI agents?
Look like he need a COVID bottle. COVID, Larry.
It's been a year. I believe so, but it's been a year.
When you say it's been a year, I'm assuming that means that there's some details you don't quite recall all the way. That be fair to say?
Yes.
So it'd be fair to say that if there's details you don't recall, how can you recall the path of travel of the SUV that you claim you saw?
Because it came past me.
Can you rephrase the question? I'm not understanding.
I think it was clear, but I'll ask again.
Objection argumentative.
You just acknowledged that there may be some details that you don't quite recall. So would it be fair to say that you don't quite recall the path of travel of the vehicle?
No,
that's
that
not
is
fair to
not
say.
correct.
Not fair to say. She lost sight of it as a
Judging
woman.
by what you just stated, wouldn't it be fair to say that that's a possibility?
No.
No.
She was very clear on her
So
testimony.
you recall all the details that you observed that evening, November 21st, 2021?
No.
She was clear on cross.
So what other details do you not recall?
Objection.
You're under, how does someone recall the details that they don't recall?
Yeah, that's what I wonder.
Sustained is to the form of the question.
Seems very funny. Seems almost as if you're recalling what you want to recall and purposely not.
Objection, badgering the witness.
Yes, sustained. You do not have to answer that, and you are warned. You may not badger or argue with this witness. Next question.
Good job, Judge. Good job. Good job.
Next question.
What do you mean?
Next question.
Don't intimidate the witness is what I mean.
How am I intimidating the witness?
Badgering the witness by eye rolling, by pursing your lips, by making facial movements regarding her
Does she
answers
feel intimidated?
is badgering the witness.
Are you kidding me?
Under 90611,
You really
please
can't- you
ask
really
your
can't
next
be serious.
question.
Do the countdown, y'all. Do the countdown.
Intimidating the witness. What have I done to intimidate the witness?
The last question was badgering, which is a form can
But you
be.
said
Mr. Brooks, I've made my ruling
Not
under
on 611.
9611.
You said
Please ask
intimidate.
a question or
I'm trying
I
to
will
merely-
stop the
How
questioning.
did I intimidate?
Under 90611, sub 1, sub A, sub B, and sub C, ask your next question or the questioning of this
How are
witness
you
will
even a
end.
judge? How are you even a judge?
All right, you may step down now. Thank you.
How are you even a judge? Come on, man. This must be all about the 62 trust, right? That you want to be the beneficiary of?
I'm going to give the jury their closing instruction. We are done with testimony for today. Please do not begin your deliberations and discussion of the case until all the evidence is presented. And I have instructed you on the law. Do not discuss this case among yourselves or with anyone else until your final deliberations in the jury room. This order is not limited to face-to-face conversations. It also extends to all forms of electronic communications. Do not use any electronic devices such as a mobile phone or computer, text or instant messaging or social networking sites to send or receive any information about this case or your experience as a juror. If you come in contact with the parties, lawyers, interpreters, or witnesses, do not speak with them. For their part, the parties, lawyers, interpreters, and witnesses will not contact or speak with the jurors. Do not listen to any conversation about this case. Do not research any
It
information.
should zoom
that
into
you
his
think might be
face.
helpful to you in understanding the issues presented. Do not investigate this case on your own or visit the scene either in person or by any electronic means. Do not read any newspaper reports or listen to any news reports on radio.
Look, they doing it. Yes. Yes. Yes.
Do not consult dictionaries, computers,
Oh.
electronic applications, social media, the internet, or other reference materials for additional information. Do not seek information regarding the public records of any party or witness in this case. Any information you obtain outside the courtroom could be misleading, inaccurate, or incomplete. Relying on this information is unfair because the parties do not have the opportunity to refute, explain, or correct it. Do not communicate with anyone about this trial or your experience as a juror while you are serving on this jury. Do not use a computer, cell phone, or other electronic device, including personal wearable electronics applications or tools with communication.
Y'all snapshot
capabilities
this.
To share any information about this case. For example, do not communicate by telephone, blog post, email, text message, instant message, social media post, or in any other way on or off the computer. Do not permit anyone to communicate with you about this matter, either in person, electronically, or by any other means. If anyone does so, despite
COVID Larry.
you should report that to me. I appreciate that it's tempting when you go home in the evening to discuss this case with another member of your household, but you may not do so. This case must be decided by you, the jurors, based on the evidence.
Shouts out to the
presented in
cameraman.
People not serving on this jury have not heard the evidence, and it is improper for them to influence your deliberations and decision in this case. After this trial is completed, you are free to communicate with anyone in any manner. These rules are intended to assure that jurors remain impartial throughout the trial. If any juror has reason to believe that another juror has violated these rules.
Oh, now he want to put his
report that
mask
to
back
me.
on.
If jurors do not comply with these rules, it could result in a new trial involving additional time and significant expense to the parties and the taxpayers. You are to decide the case solely on the evidence offered and
Screenshot
received
acquired.
at trial. I'll have the jurors report on Monday at 9 a.m. Thank you. You are excused. Please rise for the jury.
That zoom in was everything for real.
Call yourself a judge as much as bias you put up in here. Don't even tell the jury the truth. Got no integrity whatsoever. None. None.
Thank you, everyone. Please be seated.
That means you too.
I would like an update on whether Mr. Brooks filled out a subpoena for Don Woods and provided that to the state. Has that been done?
No, we haven't received anything, Your Honor, and obviously, she can appear here voluntarily if Mr. Brooks wants to arrange that. I don't believe a subpoena is necessary. We had subpoenaed her, and she was under state subpoena. So I know that at least some point she had notice, but our position would be, Your Honor, that we will not be responsible in any fashion for producing Miss Woods. Mr. Brooks talks to her on a daily basis. If he wants her here, he can produce her on Monday.
Yeah, they ain't got to worry about that.
So I just wanted to know, because I know.
Yeah, the
some
state not
people
trying to help
filled
him no
out.
more.
If
So
I want her to be here, she gonna be here.
I agree with
So
the
just
state
just
that
know that
she could certainly appear.
it ain't even got to be no arrangement. All I gotta say is come. She gonna come. That simple.
Mr. Brooks, do you intend to call her as a witness? Because I'm directing you
We
to
said-
have her
we
here
said
at
all
9
that- We said
a.m.
all that at the beginning, man. Like, I don't even want to be in here that much longer. Just do what you got to do so I can get up out of here. I'm tired of being in the courtroom that has no integrity whatsoever. How can you even call yourself a
Mr.
judge?
Brooks, I need to make a record of
I
some
need to
things.
make a record too.
You don't.
When
need
am
to-
I going to get the chance to do that?
All right, I need to make a record. He's being removed to the other courtroom. He is yelling at me. He's not going to let me make a statement or make the record that I need to make.
I'm finna
He
leave
hasn't
anyway,
sat
so
down
what do it matter?
for
You
the
can
better
hold me
part
in
of 2
contempt
hours.
all you want. You can hold me in contempt all you want.
I'm not
All
holding you
gotta
in
do is tell me
contempt.
if it's criminal or civil, so I can hit
Right.
you with you.
I need to
with
clear
what you
the
know is
courtroom because
coming.
I do need
I'm
to
gonna give
make.
you what you know is coming.
I need him to go to the
If
other
it's civil-
courtroom because I do need to put some
if
things
it's
on the
civil,
record. The record should
Where's the
reflect
contract between you and I?
that Mr. Brooks
If it's
is
criminal,
yelling at me.
what is the crime?
He is.
Who makes the claim? And what is
He
this?
is. I will make the record when we get back. I will step off, but Mr. Brooks, you're being
It ain't
taken
no
to
Mr.
the
It
next
ain't no Mr.
courtroom.
Brooks. Don't try to address me
Thank
like
you.
that, like we cool. You don't have no integrity. How can you even call yourself a judge? Making tacit agreements, being biased, judicial misconduct, trying to steal somebody's sex.
Well, we'll be back on the record shortly. So here's this. You know, I do know that there are judges who actually carry firearms. I don't know whether they carry them in the court, but I do know there are judges who do carry firearms. This case is really something. This would be a case study for how not to represent yourself. It would be, he said the cameraman is petty. It would be a case study for, do you think he would have done that if the judge were male? And just indulge me in argument for a minute. Do you think that he's doing this because the judge? Now, I like how she's standing her ground and how extra patient she is. But I remind you of the time. Let me see if I can find it because I'm on it right now, and I'll just tell you what it is. I think that if you remember the Unabomber, the case of Ted Kaczynski, and how they said if they get, because he had counsel, but I think he wanted to represent himself. And he was trying some of the similar tactics too. Not sovereign citizen, so to speak, but, and I'll look at your comments in a minute, he was going to have it where, in essence, this is his stage. Him representing himself, he knows, Mr. Brooks knows that there is a high unlikelihood that he is going to be found not guilty. He knows he's going to be found guilty. And so, if in fact what was on the Netflix documentary was true about Ted Kaczynski and the Unabomber, the FBI special agent over the behavioral sciences or the behavioral analysis unit, the BAO, at the time, or even the head of that task force, said, don't have him take the stand. That would be the greatest Like that's his stand. That's his audience. And if these theories get out to the world, it could be dangerous. Get him to make a plea. And so his lawyer, Ted Kaczynski's lawyer, was trying to plead him not guilty by reason of mental insanity. And the judge threatened that, sure, you know, if you want to represent yourself, we have to put you in a mental evaluation to see if you are competent to stand trial, at which point in time they basically were threatening him to put him in a mental home for that evaluation, or a mental part of the prison for that evaluation. And so he's not crazy. Ted Kaczynski wasn't crazy, but he was playing crazy, so to speak. You see what I'm saying? And so the one thing a non-crazy person doesn't want to do is be in the room with other crazy folk, because other crazy folk are crazy, and you not crazy, you just trying to use it as a defense. And so that judge shut it down. Like, if in fact that was the case, and I'm gonna do that. You said, I think she's doing all that. So I'm sorry, let me read the comment. I think she's doing all she can not to be used in appeal. Yeah, I agree that. Robin Patrice says, sovereigns are funny in court too, especially criminal. I'm not surprised. They're funny on traffic stops. Oh, very funny. It never works out with us. We almost do what we want within the bounds of the law in traffic stops. And I'm not referring to TV judge Mike. I'm talking about cop Mike, like real cop Mike. You said this guy is no Kaczynski. No, but I do see comparisons. This guy is no Kaczynski. Kaczynski was actually smart, who used his smarts and his skills to a disastrous end. But if you're looking at the stage, right? Granted, Brooks is on the stand saying a bunch of sovereign citizen.
That Mr. Brooks is in the adjacent
back on the record.
courtroom. I have verified the audio and video are working appropriately. I need to address some scheduling issues, but before I do that, I need to make a record that at the very end of, after I read the closing instructions, Mr. Brooks started to make disparaging remarks about the court in the presence of the jury. I did not respond to those. And once that jury left, he got incredibly loud. He was yelling at me. He, I think, had been standing for the better part of the last couple of hours, even though at one point I directed him to sit down after the direct examination of the last witness. It was apparent to me that he was not pleased with some of the rulings that I had been making regarding objections. I would just remind him that this was a witness he called, therefore it's proper and allowable under the law, under 906.11 sub 3 to be exact, for the state to ask leading questions, which they did. And at the very end of that, there was an objection based on badgering, which, as the record reflects, I sustained. His voice got louder. He continued to stand. He was being very argumentative with that witness, who, again, he called. Given his posture, given his staring, given his pursing of his lips, given the way that he kept asking the same question in different ways, but over and over, not satisfied with the responses that had been given or the court sustaining the objections, that is why I made a finding at that time and sustained the objection for badgering. It was Mr. Brooks who asked me what that meant, and I indicated it's a form of intimidating a witness. I don't mean that in the sense of there's a charge of intimidating a witness. That's not certainly what I meant, but really in the common everyday usage, it's another word, it's a synonym for badgering. Clearly he was displeased with the court. After that, I cut off the examination, which I had given a number of warnings that I would do if he didn't ask an appropriate, a probative, or relevant question. During that time of both the, frankly, even during his direct examination, definitely during the state's cross-examination and then redirect, it was very apparent to this court, and I think to anyone who was watching, that Mr. Brooks was not pleased with the witness's answers and would roll his eyes at her, or just to himself, I guess, and purse his lips and make other gestures that he did. That it was apparent to this court he did not like her testimony. And again, I'd remind everyone that it was his witness, and he had the police reports for this witness, and obviously was fully aware of her statements to the investigators in this case. So I just wanted to make a record of that. It's in part why at the very end, and given the history of today and his conduct and being removed previously, I thought it important that the court remove him at the end of the hearing outside the presence of the jury so that I could get through a couple of things. We have gotten through the witnesses for which Mr. Brooks issued subpoenas that the state assisted with. I did provide permission to him earlier today, if he so chooses, to call Dawn Woods as a witness. The only other witness at this point that I can identify that's been, for which the court and the state has been put on notice, of course, would be Mr. Brooks himself. I'm not looking for an answer today, but what I wanted to put on the record and what I will put on the record are certain advisements that he can certainly contemplate over the weekend, so that when I do the colloquy with him on Monday morning, he's had a sufficient opportunity to think about his decision to testify or not to testify. The advisements that I will give Mr. Brooks at the moment are as follows. Mr. Brooks has a constitutional right to testify. If he chooses to testify, I'm further advising him that the state has the right to ask questions of him, what is referred to as cross-examination. That may include reference to whether he's been convicted of crimes in the past. I still need to make a ruling on that, and I will do that first thing Monday morning. I will also advise him that he has a constitutional right not to testify, and that a decision not to testify, that a jury will be so instructed, not for that, they will be instructed that that cannot be used against him in any way, and there's an appropriate jury instruction on that. If he chooses to testify, the other jury instruction that is typically read simply advises the jury to assess credibility no differently than how they would assess the credibility of any other witness. There's the added paragraph to jury instruction 300. I would further advise him that it is his decision and his decision alone on whether to testify. I will ask him whether anyone has made any threats to influence his decision on whether or not to testify. I will ask him whether anyone has made any promises to him to influence his decision to testify. I will rely upon upon the record, specifically the record made during the waiver of attorney regarding his education. I will ask him whether he's had any medication, alcohol, or drugs within the last 24 hours prior to the colloquy. And I may also confirm that he's able to read, write English. Again, I may also refer back to the colloquy I had during the waiver of attorney hearings. I will then ask him whether he's made a decision, and then ask what that decision is. And then based upon his decision, I, of course, will make an appropriate finding. Given how this trial has progressed and the disruptions and some of the issues with, excuse me, consent or lack of consent, or that Mr. Brooks sometimes raises, I'm also going to advise him today that failure to answer the question on what is your decision, a failure to answer, this court will interpret as a no, meaning he will be choosing not to testify, and the jury will be so instructed. And I may ask that question more than once, depending on the circumstances. I'm also going to direct the parties to some cases that I think may become relevant about potential testimony, the scope of it. Chambers versus Mississippi. It's a U.S. Supreme Court case from 1973, found at 410 U.S. 284. Rock versus Arkansas, also a U.S. Supreme Court case, 483 U.S. 44. State versus Anthony, which is a Wisconsin case, 2015 Wisconsin 20. These cases, of course, recognize that a defendant in a criminal case has a fundamental constitutional right to testify in his or her own defense. Of course, that right stems from various constitutional provisions, including the 14th Amendment, which protects a defendant's due process rights to be heard and offer testimony, the 6th Amendment, which protects a defendant's right to call witnesses in their favor, and the 5th Amendment, which protects a defendant's right against compelled testimony unless he chooses to speak on his or her own behalf. I'd also point the parties to State versus McDowell, 2004 Wisconsin 70. Although the right to testify is a fundamental constitutional right grounded in personal autonomy, it is not absolute. There is no constitutional right to present irrelevant evidence. State versus Robinson, 146 Wisconsin 2nd 315.
Yes.
Moreover, a criminal defendant's right to present relevant testimony is subject to reasonable restrictions. Citing to Rock versus Arkansas, there's a balancing test that if and when this court is faced with any of these situations that I will be prepared to go through. Of course, Illinois versus Allen is also important, and all of the other cases that I've cited along the way. State versus Anthony is also important, as I've noted previously. I've relied heavily, of course, during the course of this trial on 906.11. And the primary purpose of a criminal trial is to develop relevant facts on which a determination of guilt or innocence can be made. Efficiency is a secondary objective of trial. And of course, it is the circuit courts and the judges assigned to those circuit courts that are charged with administering the trial and serving these two purposes. So just tying up, I guess, the last loose end. I've referenced it already, but I think it's worth repeating again. If the defendant wishes to call Ms. Dawn Woods to the stand, I expect her to be here. I expect one of two things to happen. Either
Just
he
put a poll up
testifies
there.
first or he doesn't, or he
Do you
calls.
think he would
You
testify?
can certainly call her after
Just put
he
a poll up there.
testifies. But if she is not here at 9 o'clock, when I've advised the jury to be here, I will, of course, have gone through the colloquy with Mr. Brooks. And I expect people to be on time and to be ready to go, to be fully
Y'all think he
prepared.
will? Damn.
And then, of course, the state, if it so chooses, does have the option to call rebuttal witnesses and offer rebuttal testimony.
We would not anticipate that as of
Can you all see the poll?
So you know for timing.
Thank you. I appreciate that. Because once the evidentiary phase of the trial is closed, of course, I will be sending the jury home because I do anticipate a very lengthy jury instruction conference. And it's my hope that that is something we can get done by the end of the day on Monday, but since it's just the parties and not a jury here, I will go as late as it takes with the hope of, and with the plan of, again, assuming the state doesn't call any rebuttal witnesses, to start instructing the jury on Tuesday morning. I anticipate that is going to be an incredibly lengthy process. We have been working, Madam Clerk has been working very hard on pulling together, just from what we have thus far, the jury instructions. I believe it's well over 100 pages. Yes, with my advanced eyes, I need 14-point font. So with that caveat, but the preliminary instructions were 69 pages with the 14-point font. So I know it's going to take some time. I know I'm going to need some breaks. I do not anticipate getting done with, so I keep saying preliminary, but I don't anticipate getting done with the advisement of the jury instructions before the lunch hour. I can't tell you how long it's going to take. It may take the whole day, but the party should, well, the state would go first, so the state should be prepared perhaps to start closing arguments. I'll
Yes.
ask you on
We
at a
will
later
do this
point,
again
probably
Monday.
sometime on
Yes.
Monday, if you have an
I'm
idea
gonna
of
stream
how
it.
long
I'm
that
having
will
fun
be,
doing
because
this.
that will frankly dictate in part like where we are with how long it takes for me
Monday
to
at
go
9 a.m.
through
We will
the
be back.
instructions, and whether I
This was
just
fun.
instruct and then bring the jury back the next day for closing arguments. But that's generally the framework that I intend to follow. Any questions about any of that from the state?
Nothing about any of that, Your Honor.
Anything
have a
you
few
think I
other
need to
things.
address before I turn to Mr. Brooks?
We do have two things to clear a record about.
Go ahead.
Do that now.
Yep.
The first is for the testimony of two different witnesses. We provided Mr. Brooks with summaries of those witnesses' statements as recorded in the police reports.
No
First
problem.
was Deanna Aldrich. That included a piece of paper containing 3 paragraphs, which summarized Ms. Aldrich's statement to the Waukesha County Sheriff's Department as they were memorialized in supplement number 55 under an incident report number
COVID, Larry.
W21087731. The second of those was a 1-paragraph summary of the statement provided by Jason Hayes to the City of Waukesha Police Department, memorialized in supplement number 28 under incident report number 21047-493. These were, again, documents that were provided to Mr. Brooks in the discovery process, but we sought to be helpful in his presentation of evidence here at the trial today. The second issue that we'd like to make a record about relates to the testimony of Erica Patterson. So for the record, I think it's important to note that the 2 photographs the defendant attempted to show that witness and presumably put into evidence depicted what I believe to be the defendant and Ms. Patterson's 15-year-old daughter, as well as their new grandchild, the daughter's child, who was born around May 1st of 2022. I think that there was ample grounds for the court to end Ms. Patterson's testimony when it did, but for just in case that becomes an issue going forward, I'll make an offer of proof that Ms. Patterson, if asked about those pictures, would have testified that she did not provide them to Mr. Brooks. She provided them to a person named Michelle, who I believe is a mutual friend, who in turn provided them to Dawn Woods, the defendant's mother, long day, who then, that was the person who provided them to Mr. Brooks. If she were forced to answer questions about this supposed letter that Mr. Brooks was claiming to exist, she would have testified that she has not written a letter to Mr. Brooks since he came into our jail on November 22nd. She didn't write one on November 21st either. At any point between his being taken into custody and today. It's my understanding that he has tried to call her from the Waukesha County Jail on 37 occasions. She has never accepted a single one of those phone calls. And finally, during the early lunch break, I was informed by the bailiff staff that the defendant was twice offered to go to his cell to retrieve that letter that he talked about. He declined both times.
Thank you. I appreciate the record being made. I will now unmute Mr. Brooks and ask him if there's anything he needs to make a record of
Oh,
at
here
this
we go.
point on the topics that have been raised.
He ain't been paying attention. He even had the earphones in. He hadn't even had the earphones, so he didn't hear none of the stuff that was. Oh, you're in that black box. He in the black box handcuffs because he was aggressive.
Sir, anything you wish to address before we break for the
No.
day?
Yeah, I wasn't really hearing everything that was just said good, but why haven't I been given the chance to offer all my filings and the evidence when I already stated that before? I would like all my filings. I would like every single filing that I filed placed into evidence. Every last one of them.
It's already in evidence.
That has yet to be done.
You have to.
I put you on notice, and I've stated it on the record, even before I even had a chance to start calling witnesses and put on a defense that I haven't even been adequately been able to do. So this is something that's been stated on the record numerous times. I did hear a reference to what was he just talking about? Whatever he was just talking about is in regards to me going to get the letter or whatever the case may be. First of all, it's not just one letter, like I stated before. And for somebody that don't even know to try to tell me what I got, like you need to cut it out, man.
Sorry, hit my mic.
Y'all need to cut it out.
Tell me what
Seriously.
I got. Tell me what I
stop it. It seems to me that all y'all been wanting to do is gang up, be biased, be prejudiced, and gang up. 4 against 1. You sit up there earlier and made a record before the lunch. You sit up there and made a record about all this stuff that happened in Nevada. That's other acts evidence, ain't it? How was you allowed to put that on record and not even be truthful about everything that you said? But not one time did somebody say, no, we're going to strike that. Not one time. But if it had been me, it would have got struck. Or if it had been me, it would have been a problem. If it had been me, I'd have been held in contempt. Why was the bond not addressed? Why was the statement of particulars not addressed? No filings that I seem to file need to be addressed. After you sat there and told me that that's what I needed to do, then you want to refer to the waiver of counsel, which, again, for the record, you accepted it the way that I gave it to you, which clearly states on there, I do not waive my right to assistance of counsel, and you accepted that. But you still turn around and continue to violate my Sixth Amendment right. Violate my First Amendment right by telling me what I can and can't say.
Shit. He didn't have a bunch of First
right
Amendment
to say whatever I want
allowances.
To say and to be heard. That's the First Amendment.
Boy, you definitely had the First Amendment in your favor.
You sit up here and talking about a fourth option that you came with out of the blue for Illinois versus Allen when there is no fourth option. Then you try to sneak some other case laws in that you just came up with today. I don't know if you came up with that when you was on one of your breaks that you take, but that it's awful funny that it never got mentioned before. You've repeatedly made a false record. You want to sit up here and perpetuate all this disruptive behavior and this, that, and the third, when you knew from the point of the start of this trial, one, that I wasn't prepared, two, that I did not understand the proceedings.
That's the risk you take when you represent yourself.
Yet still you choose to find a way to get around it. Just like you found a way to get around answering what your name was, which you're a public servant. The name that you have on file with the Secretary of Treasury and State, however you want to put it. You were asked for a certified copy of your oath of office, which you stated on the record you would not provide. Didn't give any case law why you don't have to provide that. Have yet to prove subject matter jurisdiction for the record. Have yet to show that you even have a license to practice law. Haven't proven that yet. And neither has the prosecution. Where's the licenses? Why can't I place your oath of office into the record? Why can't I make that part of evidence? The oath that you haven't even honored, not one bit. Doing enough to keep your face clean doesn't constitute being fair.
This is all First Amendment expression, by the way. All First Amendment expression.
I struck the whole jury. That never got addressed in any way, shape, or form. When you were informed way before that I was striking the whole jury. So how can you go over that constitutional right, which I have the right to not pass a jury?
Mr. Brooks, I'm muting you. And the reason I'm muting him is because he has not addressed a single issue that was raised at the end of this hearing today. He is simply rehashing previous determinations of this court. I would describe it as a rant. He continues to impugn the integrity of this court and this process. Again, he did not address any of the issues that I raised at the end of this hearing. From my perspective, the issues that he is raising are all related to claims that a sovereign would make, someone who claims to be a sovereign citizen, claims that have no base, that are baseless in law and in fact. I'm not going to address them any further. Again, they are simply baseless. And with that, I'm going to end for the day. I'll see the parties at 8:30 a.m. on Monday. Thank you, everyone. We are in recess.
And there you have it. A tough case because of the constant outburst and sovereign citizen dictates and mandates and all the different statements by Mr. Brooks, the defendant in this trial, the people of the state of Wisconsin versus Darrell Brooks, where on or about November of 2021 in the city of Waukesha, the county of Waukesha, Wisconsin, Mr. Darrell Brooks is alleged to have taken, after a domestic violent encounter, altercation, and physical altercation with his ex-girlfriend, the mother of his child. After that situation, he then took his mom's red or burgundy Ford Escape and then drove it through the holiday parade that was taking place at that time. The results of that culminated in 6 people what was 5 at the time of his taking into custody, his apprehension. Later, at the time of his bond hearing, was 5 people, later determined to be 6 because a young child passed and expired. And he was charged with 6 counts of intentional homicide. Wisconsin does not have the death penalty. Wisconsin has life imprisonment. And upon conviction of this case, he is facing 6 life sentences, where there are also charges of various charges of the harm that he has caused to other people. And in this case, he is claiming himself to be a sovereign citizen. He has attempted to delay the process. Normally, there's a defendant demands trial. There's a demand for trial, a speedy trial by jury. But the only person in this case who has attempted through every means possible to stall the swift application of justice in this case has been none other than the defendant himself, Mr. Darrell Brooks. By the way, for the record, he refers not to be addressed by that name. He does not consent to that. That has already been entered into the record. And Judge Jennifer Darrell has done the best that she could, notwithstanding the criticism that she's receiving from other people. I don't know if it's jurist or not, which I doubt it is, but the public thinking that she should silence him and expedite this trial, perhaps because of the impatience of the public and the desire to see swift justice, all while not understanding the tenets of the law, not understanding that it is that the jury, they are the triers of fact. The judge is the trier, and if you will, the coordinator of the law. The judge has to make sure that the record reflects what it needs to reflect, what it's supposed to reflect, all while preserving the rights of the defendant. Sometimes people don't see that. Sometimes people see the judge as working in concert with the state, while not taking into consideration that the judge is supposed to be a detached and neutral magistrate. In some court cases and in some courts of law, you may not see, or it may appear, or it may have been proven that the judge, the scales of justice are supposed to be even. Justice is supposed to be blind. But in certain cases, you can see that the judge works with the state. But in this case, I believe that the judge is doing beyond the best that she can to, one, maintain her composure, to make sure that she is going above and beyond what would be considered necessary to ensure the rights of the defendant, to ensure that this isn't an unfair prosecution, and to ensure that the record reflects as much as it can, because of so many things that take place. It's sometimes hard to keep up. And it's actually a good thing that there are cameras in the court so that some of this stuff can be reviewed, so that, and I know the jury is not supposed to view things, but I don't know if that prohibits the judge from doing that. And so it's good to perhaps go back and see things, because sometimes in the constant things that happen, sometimes so fast, sometimes under the influence of emotion, sometimes just being drug out long. Sometimes you miss things. And I think that she's doing an outstanding job. There will definitely be an appeal. I don't see that not being the case. But I think it would be hard to find issues where the appellate court would find that the judge did not, one, preserve the record, two, preserve the rights of the defendant, three, allow him whatever constitutional rights that he has coming to him, given that he is a defendant. And apparently, Mr. Brooks did not read the case in its entirety, because if you look at, and I'm going to switch the screen again. If you look at Illinois versus Allen, and I know some of you all are saying I'm confused what's happening. You kind of walked in on the back end of it. We've been live for 4 hours. So you may have to watch the replay if you want to, but we're reviewing this. Here's Illinois versus Allen, right? A defendant can lose his right to be present at trial if, following the judge's warning that he will be removed if his disruptive behavior continues, he nevertheless insists on conducting himself in such a disruptive manner that his trial cannot proceed if he remains in the courtroom. He can reclaim that right to be present as soon as he is willing to comport himself with decorum and respect. And this is Illinois v. Allen, 397 U.S. 337, 1970. This is the United States Supreme Court case. But this is the point that I was trying to, let's read the rest of it. It's not long. A trial judge confronted by a defendant's disruptive conduct can exercise discretion, which he totally did, to meet the circumstances of the case. And though no single formula is best for all situations, there are at least 3 constitutionally permissible approaches for the court's handling of a I'm about to sound like his ass now. Fuck it. Defendant. We're going to get that word. I'm going to Google the shit out of that. Okay. I sound like him. Bind and gag him as a last resort, thereby keeping him present, for which he was not. In fact, you didn't see him and his hands be restrained except for the last moment, the last point. The last point where his conduct was so aggressive, where it would not be out of the reach and the mindset of the jurors, the judge herself, the district attorneys, and other parties in the courtroom, observers, witnesses, that his conduct would have been extremely aggressive and has been extremely aggressive, and not too far-fetched if he were to physically attempt to assault the judge, the district attorneys, or anyone else. Okay. Yeah. And here's another part. Here we go. Number 2, cite him for criminal or civil contempt, which she has not done. She has not done. Or 3, remove him from the courtroom while the trial continues until he promises to conduct himself properly. And as the judge properly stated, this case was 1970. Technology was different then. I wasn't even born. Maybe the judge wasn't either. Who knows? I don't know. Whatever. But in the day and age where we now have Zoom and other types of technology, Mr. Brooks has been able to be a part of the trial, has been able to participate, whether he chose to or not. Things have been present to allow him to be able to assist in his own defense. And in fact, conduct his own defense, given that he's representing himself as pro se counsel. And number 3, on the facts of the case, the trial did not abuse in his discretion. Respondent, through his disruptive behavior, having lost his right to confrontation under the 6th and 14th Amendments, Mr. Brooks has been citing over and over and over and over and over and over again that he has a 6th Amendment and a 14th Amendment right to confront his accusers, and the judge, along with the state's attorney, or the district, in Cook County, we're used to district attorneys, but the judge and the district attorneys have gone over and above and beyond what some courts may not even do. And that's give him as much assistance that they can without compromising their case, their position, and or their duties. And so it's going to be interesting to see next week. We're almost done. It's going to be interesting to see next week It's going to be interesting to see if he testifies what those admonishments would look like, what those questions would look like from the judge and his responses. That's going to be more, I mean, the judge is going to do pretty standard stuff. She reads from a sheet. They all do. You know, these jury instructions, you know, and admonishments are established by Supreme Court rule, and then some by state statute. There are websites where you can actually go view that. I know in Illinois that's the case. But what's going to be more funny, if anything, and then extremely disruptive, is going to be his responses to these statements. And I think he's going to take the stand. I think he wants to tell his story. I think he wants to be heard. He wants to be heard in this matter. He wants to be heard. He's been wanting to be heard throughout the entire trial. And he's taken every opportunity to make sure that he has objected. Some objections made sense and they were sustained. Other objections, in fact, the majority of his objections were frivolous. But he was allowed to make them. Mr. Brooks talked about his First Amendment rights being violated, but even me, not being a judge, not being an attorney, but having an understanding of the law, having an understanding as a criminal justice practitioner, both past and present, having been in the courtroom plenty of times and been involved in cases and things of that nature, I would have to say that if ever was the case that a person's First Amendment rights have been granted to them and not even having been restricted, except up to a certain point, pursuant to Illinois versus Allen and 90611 of the Wisconsin statutes, this is such a case. This is such a case where she has exercised more patience than I would argue some other judges probably might not have exercised. If ever were a case of testing the limitations of professional decorum, and we all have a personal temperature, if you will. If ever were a case of testing one's energy to have the patience so as not to lose it herself or himself, this is such the case. This is such the case. And I'm interested in seeing what's going to happen next week. So we are definitely going to stream this on Instructor Mike page with TV Judge Mike. That's what it's going to be called. It's going to be called TV Judge Mike. And we are definitely going to stream this because I'm curious. I'm curious to see how it's going to go. And I appreciate you all in the audience. So yeah, come back at I drop off my daughters. Now I take my daughters to school, right? So I will make sure 8:45. 8:45. Okay. So 8:45, we'll be back in the courtroom. Okay. 8:45 a.m. I can't even say Central Standard Time because we're in the same time zone. We're in Wisconsin. So yeah, 8:45 Central Standard Time. We'll be back ready to go. And I hope you all come on in. For those of you all who did, it's going to be Instructor Mike. It's going to be TV Judge Mike. And I got to put the TV on there because, for the record, I am not an attorney. I am not a judge. I am just a TV judge. I play one on YouTube TV, right? For the record. And this is not legal advice. This is just my opinion based upon my observations, based upon, my knowledge of the criminal justice system, with a resume long enough to state that I understand most things and I'm still ignorant to certain things. But I'm definitely going to continue to opine because that's what we do, right? So that is my disclaimer. Yes, Lisa, I had to state it. I had to. Yes, I am not an attorney. I am not a judge. I just play one on YouTube TV. So don't think you're going to be sorry. This is not legal advice, right? This is just for entertainment purposes only. Just like the doggone, just like the trial itself even though that's a real criminal trial. Okay. But this is going to be interesting to see. Okay. So for all of you all that did give cash apps or donations and stuff like that for my children's books, I just put the Zelle and the PayPal across. Every $5 donation goes towards my children's books. I'm a published author. I have 36 now children's books. And when you give me the $5, that goes towards giving a child a book. Okay. Go to my other YouTube page, author Mike and Friends, author Mike and Friends. This is not legal advice. No, author Mike and Friends. You have the books on video so your kids can watch, right? You can go to MikeBrownsBooks.com, look at the books that I do have, pick one, whatever, I'll be able to send it to you, or just donate so I can give it to a kid. It's important. Okay. Yeah. Outstanding. Okay. I will see you all Monday, 8:45. If there be nothing else, court's adjourned. See you soon. See you Monday.